আমি স্টার্ট করে দিচ্ছি।
Assalamu alaikum and a very good morning to you all. It is my pleasure to heartily welcome you all to the final of the first ever BIAC Inter-University Arbitration Contest 2020. This is the first arbitration contest in the history of Bangladesh which is completely conducted in digital platform due to COVID-19. Our media partner for this contest is Daily Bonik Batta. This program is being live streamed in BIAC's Facebook page and LinkedIn profile. Dear all, BIAC is the first and only licensed and registered alternative dispute resolution institution facilitating resolution of domestic and international commercial disputes through arbitration and mediation Bangladesh. BIAC started its operation since April 2011. BIAC has developed all the facilities required for systematic and comfortable arbitration and mediation proceedings. BIAC has its own arbitration and mediation rules. Apart from facilitating arbitration and mediation, BIAC also provides training courses on ADR, especially arbitration, mediation, and negotiation, to develop a pool of human resource in this field. Recently, BIAC has taken an initiative of providing ADR training courses for university students. Since inception, BIAC has been working hard to create awareness about ADR methods by conducting several outreach programs, seminars, workshops, and dialogues. Recently, BIAC decided to extend its activities by introducing this contest for students who want to carve their path in this field in the near future. From now on, BIAC will be hosting inter-university arbitration contest every year. This year, due to the COVID-19 pandemic, we are conducting the contest through virtual platform. But from the upcoming years, we plan and hope to be able to conduct the contest upfront on BIAC premises. This year, 4 of the leading universities of Bangladesh took part in this contest, which are University of Dhaka, the London College of Legal Studies LCLS South, Independent University Bangladesh IUB, and Bhuiya Academy. In the first round, Dhaka University attained its place in the final by competing against LCLS South. And in the second round, Bhuiya Academy won against IUB. Today, for the final, we have Dhaka University as the claimant team and Bhuiya Academy as the respondent team, striving for the champion trophy. Today, the champion, runner-up, best teamwork, and best participant of this series of contests will be declared at the end. As this year, the series of contests will be, as this year, the competition is being held in digital platform. BIAC has decided to conduct a prize-giving ceremony to hand over the champion and runner-up cup and distribute the certificates to the students on 9th November 2020 in the afternoon at BIAC premises by maintaining social distance and necessary precaution for COVID-19. Both teams has 6 team members who will play roles of coordinator, counsels, witnesses for their respective sides. 60 minutes have been allocated for each team to present their cases. Within the 60 minutes, 3 minutes for introducing the team members, 7 minutes for opening statement, 20 minutes for examination in chief, 20 minutes for cross-examination, and 10 minutes for closing statement. Both teams already submitted their submission to the tribunal and other party. Soon we will May I now introduce our today's chairman and members of the tribunal. We are extremely honored to have with us Barrister Ajmalul Hossain QC, who is a senior advocate of the Supreme Court of Bangladesh and Queen's Counsel, England and Wales. He is a registered foreign lawyer of Singapore and fellow of the Chartered Institute of Arbitrators, UK. He acts as arbitrator and mediator in cross-border and domestic disputes and sits on disciplinary panels and tribunals. His expertise extends also to the laws of Bangladesh, India, Pakistan, UK, and European Union. He advises the government and the Parliament of Bangladesh on constitutional matters and the commercial dispute resolution issues. Along with him, today we have with us Barrister Sami Sattar, Advocate, Supreme Court of Bangladesh and Head of Chamber, Sattar and Company, and Barrister Margub Kabir, Advocate, Supreme Court of Bangladesh and Senior Associate, Hawk and Company as members of the tribunal. Now it is time to start the contest, and I would like to hand over the stage to the chairman of the tribunal, Ajmalul Hossain sir, to start and run the contest. Good luck to both the teams.
Good morning and Assalamu alaikum to everyone who is participating in this program and of the contestants primarily and my colleagues who are going to be judging. I'm delighted to be part of this program this morning and to chair the final round. I apologize for being a little late in starting because it was my watch which I didn't actually look at, and I'm actually chairing from Singapore. So this is on a sort of digital platform. So I'm chairing from Singapore. I went out of the hotel where I'm staying at the moment for a few minutes, and I didn't realize what the time was. Now, if this were a real proceeding which was taking place, then as chairman of the tribunal, I would probably have come and said, we were discussing the case, but that is not the case on this occasion. So there we are. I'm delighted to be chairing it and would like to hear your submissions, and eventually, obviously, we will be deliberating. And what I propose is that perhaps if it is possible, that to show you our deliberations, the discussions that we have as chairman behind the scenes, the tribunal behind the scenes. So that will give you an idea about what issues are important for us as judges deciding a case, and also the thinking process of the tribunal. So I think that may be helpful as advocates to find out how we actually react to the submissions. And in that way, it may be useful for you when you're doing this for real in the future. So I wish you all the best, and I look forward to some excellent submissions being made today. Thank you very much. I think we probably need some guidance from someone as to what happens next.
Sir, should we just start the proceedings?
I think so.
With the introduction. And
yes. What is next on the
claimant? I think what is required in the next stage is for the claimant to introduce their team and start with their opening statement.
Okay. Perhaps since you are here, Margub, why don't you introduce yourself as well and say a couple of words just to encourage the teams. And then Samir can follow after that.
Good morning. Assalamu alaikum. This is Margub Kabir. I'm actually a junior of Barrister Rafiqul Haq. I've been working with him for a considerable period of time now. I personally have some experience working in arbitration with my senior and also my senior, Mr. Ajmalul Hossain QC as well. And I'm really looking forward to all the participants, their deliberations and everything in here. feel free to be yourself and do your deliberation. This is a mock, so you have the advantage of, not getting everything too wrong. And, it's the experience basically. So the throbbing that you have right now will go away as you speak. So good luck, and we look forward to that.
Assalamu alaikum, and good morning to you all. This is Samir Sattar. I'm very happy to be here and very honored to be with my direct senior with whom I've worked for many, many years. Ajmal Hossain sir was my direct senior for whatever I've learned from him since I was a trainee up until now. And since actually I was a student in London. So I've managed to learn from the best, and I hope you will all benefit from whatever guidance insight he can provide to us as the co-arbitrators, as well as to all the participants. Obviously, what makes a good team is obviously the one that rolls with the punches and do not over prepare. So with that in mind, I'm very excited to hear all of your submissions and also the body language of the witnesses that are going to appear before the tribunal. So I think, sir, if you allow, I think let them start.
Yes, please. The opening team, claimants team, can you please start your submissions? First of all, introduce your team, and then can you please start on your submissions? Thank you very much. I'm going to be muting myself for the moment.
I think the claimant team is University of Dhaka, and Raihan Rahman is the coordinator who's going to be making the introduction. May I invite Raihan Rahman to start the proceedings, please, or at least introduce your team and take it forward. শোনা যাচ্ছে না আপনাকে।
Am I audible to this tribunal?
You are now.
Sorry for the inconvenience.
No, it's all right. I can hear you now. Thank you.
Honorable Chair, members of the tribunal, and everyone present today, a very good morning to you all. This is Raihan Rahman, coordinator of the team representing University of Dhaka in this mock arbitration between Bangladesh National Oil Company Limited and China Oil Company Limited. We have 6 members in total. As counsels, we have Mr. Ali Mashraf, Mr. Sudipta Bhattacharya, Ms. Bushra Haq, and Raihan Rahman, that's me. As witnesses, we have Nabila Rubayat, who will be performing as Shamima Akhtar. Shamima Akhtar is the former Director of Business Operations at BNOC. Then we have Mr. Jalaluddin Ahmed in the role of Mr. Kausar Ahmed. Kausar Ahmed is the current Director of Legal Affairs at BNOC. Our oral submission will be initiated by Mr. Ali Mashraf, who will be delivering his opening statement, which would be followed by the direct examination of witness Shamima Akhtar by the counsel Sudipta Bhattacharya. Later on, Mr. Kausar Ahmed will be direct examined by our counsel, Ms. Bushra Haq. The witnesses of respondent Hunsuk Wangru will be cross-examined by our counsel, Ms. Bushra Haq, and Chingru Nachang will be cross-examined by Mr. Ali Mashraf. Again, I will return with the closing statement, and throughout the entire session, I'll be moderating for my team. If this tribunal is well introduced with my team, may I please call upon Mr. Ali Mashraf to deliver his opening statement.
Yes, please go ahead. Mr.
Thank you.
Ashraf.
Honorable Chair and members of the tribunal, am I audible to you all?
Yes, you are to me and my colleagues,
Yes.
I think, as well.
Much obliged. Honorable Chair and members of the tribunal, I am Ali Mashraf, the counsel representing the claimant in today's proceeding, Bangladesh National Oil Company, BNOC. At the onset, I would like to refer to para 10 of the case, which provides the very basis of us coming into today's arbitration proceeding, which confirms the arbitral clause in the contract. It confirms the jurisdiction of the tribunal, the seat and language of the arbitration procedure, and the BIAC arbitration rules 2019 as governing the arbitration procedure. All these have been accepted by the respondents in their submission, and they have also agreed to the laws of Bangladesh as the applicable laws in today's proceeding. Hence, we will contest the issues that they have objected to in their written statement and only come back to these issues if the tribunal raises any specific queries. Honorable Tribunal, moving on to the brief summary of the facts, China Oil Company and BNOC negotiated a 20-year production sharing agreement and an operating agreement to explore, drill, and produce oil. The tenure of the PS agreement was from 1992 to 2012, that is 20 years. Honorable Tribunal, if we see the facts in para 2, 3, and 4, it is clear that at the last moment, China Oil informed that it was required to use a subsidiary named Shanghai Oil incorporated in Bangladesh to be the only party to the two contracts. Prior to that, they were the sole party who negotiated the agreements and who raised the bid themselves. China Oil assured that this was just an internal corporate necessity that would not affect the relation between the parties, but could not get the leaders in China to provide a written guarantee of the contract's performance. Now, all on a sudden, Honorable Tribunal, if we move to page 7 of the written statement of the respondents, it gets clear that they are now denying that China Oil is the sole respondent in today's arbitration proceeding. We further move on to their submission and we see that in page 7, they say if the parent entity and subsidiaries have highly mixed corporate personalities and the cost to distinguish the property is too high, the court can decide to pass the corporate wheel of limited company and order the parent company to assume the liabilities or debts of the subsidiary. It's very much clear that Shanghai Oil was the subsidiary to China Oil, and as subsidiaries, they have in general independent liability. However, if we look into the fact that Shanghai Oil did not have any assets or any employees of their own, while Shanghai Oil did not have any of these, and China Oil provided them these, and at the same time repatriated all the profits to their own bank account in Hong Kong, it becomes clear that they are the one in management and control of their subsidiary company. This attracts sections 195, 197, and 199 of the Companies Act 1994, which says that lifting the corporate bill by the government can be done for the purposes of determining the real owners or determining who have a financial interest in the company and finding out who holds controlling power on the management of the company. It has also been expressly established in two specific case decisions that we have referred in our written submissions: Free Will India Limited versus Veda Mitra, reported in AIR Delhi 258 in 1969, as well as the ICSID interim award in the much popular Dow Chemical case. Honorable Tribunal, hence we believe that it is China Oil today who are the actual respondents in the proceedings. Honorable Tribunal, we would like to point out some discrepancies and irregularities in the respondent's submission. The respondents' gross and willful negligence is very much present in their statement, where they state Nagoya Pacific Company Limited as the claimant in the notice. We vehemently object to this and state once and for all that BNOC is the sole claimant in today's proceeding. Moreover, BNOC has waived all its sovereign immunities as mentioned in the case para 5, the last line. The deed presented as an exhibit wrongly mentions BNOC as the government of the Republic of BNOC. We've already cleared that there is no sovereign immunity of BNOC in this proceeding. Furthermore, the preamble wrongly states Petroleum Exploration and Production Act, Chapter 150 of the laws of BNOC 2000, a law that does not exist in Bangladesh. Honorable Tribunal, only Article 1 and the clause containing the arbitration agreement are the given facts. The rest are unknown to the claimant. We are unaware of these facts and cannot ascertain their validity. We humbly request the panel not to take this evidence into account. If we move on to their written submission, we see that they have agreed that decommissioning could be an implied term as referred in page 10 of the written statement, but state that this obligation needs to be mentioned under a statute by referring to two in English cases. Honorable Tribunal, we firstly reply that implied terms can not only be implied via statute or common law, but also by trade or habit, professional custom, terms implied to give business efficacy to a commercial contracts, etc., as detailed in Chris Turner's treatise Unlocking Contract Law, page 99 and 100. Along with certain other English case law decisions, as Bangladesh is a company, Bangladesh today follows the jurisdiction of the Contract Act 1872, which has been derived mostly from the English law. Hence, we believe these cases are pertinent, and this principle is also pertinent today. Honorable Tribunal, we have stated that this is an implied obligation for today's respondents. Similar to the claimant, they have authorized the tribunal to abide by principles of equity in cases where substantive law remains silent. They have also referred that and admitted that this tribunal can take into account trade and business practices. Decommissioning is a trade and business practice of international petroleum industry, as it is a part of the principle of Lex Petrolia now. TCC Childs, an author and an authoritative figure in the field of decommissioning, states in 1999 in his work that it has already now become a customary international law. We further submit the treatise of Claudio Duval and others who define good oil field practices as those practices and procedures employed in petroleum industry worldwide by prudent and diligent operators under similar conditions and circumstances, having regard to factors such as conservation of petroleum resources, operational safety, and environmental protection. Honorable Tribunal, until late 1980s, most contractual agreements in the oil and gas industry did not contain express provisions regarding decommissioning or plugging. Host governments only mandated the contractors to carry out undefined measures appropriate to good oil field practice. The Bangladesh Petroleum Act 1974 mandates in Section 6, subsection 1 and 2, the duty of any person involved in petroleum operations to ensure that it's carried out in a proper and professional manner in accordance with good oil field practice. It stipulates the duty of any person involved in petroleum operations that it shall also take into account factors of environment and ecology. We've already stated how Lex Petrolia, which is practice of international petroleum industry, where foreign companies exploring oil or gas pay for decommissioning. International practice suggests that operators will bear all costs of operation of the petroleum fields, including decommissioning. They have also agreed to this particular submission in pages specifically 11 and 13 of their written submission. In page 13, they agree that an implied term for decommissioning could be present. The Bangladesh Environment Conservation Act 1995 and Rules 1997, when read harmoniously, make it clear for red category industries to share plans of relocation and rehabilitation. It is their submission where they state relocation means moving to a new place and establishing one's home or business, and rehabilitation means the restoration of former rights, authority, or liabilities. Honorable Tribunal, the Environment Conservation Act and rules state that any red category industry, which our honorable respondents are, since they fit in serial 65 in Schedule 1, that is exploration, extraction, and distribution of mineral resources, that they have to receive an environment clearance certificate. And to do so, they have to share relocation and rehabilitation plan. If we look into the case of Nigeria today, which is similar to Bangladesh in the terms that they do not have express legal provisions in their statutory laws about decommissioning, they follow international law practices, which similarly like Bangladesh mandate decommissioning for environmental regulations and similar purposes. It is our humble submission that back when the contract was signed, it was not possible and the laws had not developed to include an express provision on decommissioning. It was an implied condition, as we have already mentioned, and an implied term by statute as well as practice, and trade and business practice can be taken into account by this arbitration tribunal as per Rule 23 of BIAC arbitration rules, which both the claimant and the respondents have authorized the tribunal to do so. Honorable Tribunal, we lastly propose that the parties jointly undertake this activity and be liable for the costs in the ratio of 70:30. That is, the respondent bears 70% of the costs of abandonment, decommissioning, and plugging of the wells. Shanghai Oil, the subsidiary, was permitted to sell all production necessary to recover its costs, and afterwards 70% of the surplus would be kept to them. Current day contracts, Honorable Tribunal, state express provision of decommissioning to fall solely on respondents. However, the claimant still opts for burden sharing of costs as per equitable solution in the situation that we be jointly proportionately held liable, and they take 70% of this obligation for the cost of decommissioning, while we will take the rest 30%. Honorable Tribunal, this concludes an introduction from my part, and if you have no further queries, our substantive submission will now be issued through the direct examination of 2 of our witnesses, and thereafter the cross-examination of the witnesses of the respondents, and at the end through the summation and legal arguments, where we will further establish the at the end of the day, the remedies that we are claiming from this honorable tribunal against the respondents. Honorable tribunal, if you have any further queries.
Thank you very much, Mr. Ashraf. I have no questions. My colleagues, I don't know whether my colleagues have any questions. Samir Sattar first.
No further questions for the moment, sir.
What about Mr. Kabir, Margub?
I just have one question. What I want to know was in relation to the, your opening statements informed about the Bangladesh Environment Conservation Act. So what you're stating is when it says rehabilitation, it includes decommissioning.
Honorable member of the tribunal, yes, it includes decommissioning. I can also state one particular example of Nigeria where I say the Mineral and Mining Act 2007. It also states that decommissioning process is substantial for rehabilitation and the decommissioning cost should be included under that. I've already stated how the Nigerian law does not have any specific decommissioning process, but the obligation is implied under their Mining Act, which is
Okay, Samir, do you have any questions?
to the Bangladesh Environment Act 1995.
No further questions, sir, at the moment.
Okay, Mr. Kabir, you're happy with that?
Honorable Tribunal, I think I have been heard. If I'm not wrong, my
That is correct.
Unstable. Did you hear my reply?
I did. Thank you.
Thank you. So we will now hear the evidence from your witnesses, right?
Much obliged.
Honorable Tribunal, may I proceed for the direct examination of first witness?
Yes, certainly you can. But I just wanted to say that I was having a little bit of difficulty hearing Mr. Ashraf just before. And I don't know whether your witness has actually said anything, but I could see her face. So carry on. If we have a problem, I will indicate to you. Are my colleagues able to hear the proceedings clearly up to now?
Yes,
I have the same problem like you, but we are
but
fine.
not for the witness.
Okay, fine. So please start your examination.
Honorable Tribunal, may I proceed for the direct examination of first witness?
Yes, please. Please go ahead.
Thank you, Honorable Tribunal. Am I audible to the first witness?
Yes.
Please state your name for the record.
My name is Shamima Akhtar.
Describe your role at the Bangladesh National Oil Company, BNOC.
I was the Director of Business Operations of Bangladesh National Oil Company, BNOC, from 1988 to 1999.
In your tenure at BNOC, did the company have any dealings with the China Oil Company?
Yes. In early 1990, the Ministry of Resources and Exploitation invited bids from international oil companies for concessions in the offshore oil reserves in Bangladesh. China Oil Company won one of those bids. China Oil is a state-owned corporation of China based in Shanghai.
When did Bangladesh government invite to bid for the disputed project?
The bid was opened in 1992.
How did Shanghai Oil Company get involved in the process?
China Oil informed at the last minute to BNOC that China Oil was required to use a new subsidiary, that is Shanghai Oil, operating in Bangladesh, to be the only party of the two agreements.
And what do you mean by the two agreements?
In late 1991, we negotiated with China Oil Company a 20-year production sharing agreement and an operating agreement. Learned Counsel, I cannot hear you. You're not audible.
Am I audible now?
Yes.
Thank you. Then before this last minute announcement of China Oil Company about the involvement of Shanghai Oil as a signatory of the two contracts, what was the involvement of Shanghai Oil in the development of terms of reference of the two contracts?
Absolutely nothing. We haven't even heard about this company before this last minute announcement.
The signatory to the PS agreement and operating agreement is Shanghai Oil Bangladesh Limited. So, who communicated with you from China Oil Company?
At the very last moment of signing the agreement, China Oil's project leader, Mr. Chengdu Nangchang, sent a fax to me stating that it was required for Shanghai Oil Limited to be the party to the agreement instead of China Oil.
What was your reply to such request, and when did this take place?
On 12 November 1991, I had faxed the project leader asking him to provide a written guarantee of Shanghai Oil's work performance.
At this time, the claimant would draw the attention of the tribunal to claimant exhibit number E2, which shows that Ms. Shamima Akhtar did fax the project leader of China Oil, Mr. Nanchang, asking for a written performance guarantee. Ms. Akhtar, what did Mr. Nanchang reply?
Mr. Chengdu Nangchang faxed me again the following day, stating that he had failed to get a written guarantee from the leaders, but he assured me that the relationship between BNOC and China Oil will not be affected.
Can you please state the nature of arrangement between China Oil and its subsidiary Shanghai? Am I audible to you? Can you please state the nature of arrangement between China Oil and its subsidiary Shanghai? Am I audible to you? Can you please state the nature of arrangement between China Oil and its subsidiary Shanghai?
Mr. Bhattacharya, I think we are having a bit of problem with the technology. Can you please go back a bit to the exhibit E2 and ask the question again and to the witness, and let's see where we get to.
Honorable Tribunal, at this time, the claimant would draw the attention of the tribunal to claimant exhibit number E2, which shows that Ms. Shamima Akhtar did indeed fax the project leader of China Oil, Mr. Nanchang, asking for a written performance guarantee. Then Ms. Akhtar, what did Mr. Nanchang reply? Now am I audible to the witness? Honorable Tribunal, am I audible?
Yes, I can hear you. I don't know about my colleagues, but yes, I could certainly hear you, but maybe the witness is having difficulty. What about you, Mr. Sattar?
I can hear him perfectly clear, sir. However, I do not see the witness on the screen.
Right.
Things may have dropped.
What about Margot?
Same here, sir. I can hear properly, but I cannot see the witness.
Okay. So let's see, she may have disconnected. Let's wait for her to come back.
Am I audible to the witness, Ms. Akhtar?
Honorable Tribunal, Ms. Akhtar has dropped off the call and she will be back quite soon.
Okay, we'll wait.
Much obliged, Tribunal.
While we are waiting, I just want to tell you that many years ago, nearly 20 years ago, I was in an arbitration involving China National Oil Corporation. And I was, the arbitration was in England and in London, and I had a tribunal of 3, and we were examining witnesses who were in China. My clients' witnesses were in China. And we started at something like 8 o'clock in the morning because obviously of time differences. And we had a break, mid-morning break, and then, went until 12 o'clock. So from 8 to 12, 4 hours with about a half an hour break in the middle, and then a lunch break. And then after that, we had another session and another 4 hours. But what is interesting is that even in those days, it was quite striking for me because that was the first time that I was involved in an arbitration where we were taking witnesses through the video link. And what was interesting was that during the whole session, the line did not drop a single time. So after 20 years, when I see this happening, I'm just worried that what is happening. But anyway, but that was a closed line, which the tribunal and the witnesses at the other end in China. So obviously, but this is a much bigger line, and obviously there are many participants over here. So obviously I can see that there can be a drain on the resources. But nevertheless, we didn't have any problems. Okay, here, the witness is
I
back.
could join back in.
Am I audible to the witness, Ms. Akhtar?
Yes, you are. Yes.
My last question was, what did Mr. Nanchang reply?
Sorry? So Mr. Chengdu Nangchang faxed me again the following day stating that he had failed to get a written guarantee from the leaders, but he assured me that the relationship between BNOC and China Oil will not be affected. And the fact that Shanghai Oil was signing the agreement instead of it was just an internal corporate necessity. He stated Shanghai Oil was a subsidiary of China Oil being incorporated in Bangladesh.
Can you please state the nature of arrangement between China Oil and its subsidiary Shanghai Oil regarding the performance of PS agreement?
Shanghai Oil was the signatory party to the PS agreement, but in the performance of it, Shanghai Oil had no employees or assets. The management of assets and employees was in the hand of China Oil Company. It provided all its capital and employees.
Since the management of the Shanghai Oil was in the control of China Oil Company, was the profit made from the project in control of China Oil Company too?
Yes, all profits were repatriated to China Oil Company's Bank of China account in Hong Kong.
Are you aware of the today's dispute?
Yes.
Then I'm sure you know your company is holding China Oil Company and not Shanghai Oil responsible for today's dispute. Do you have anything to say on that?
I have already mentioned on how even though Shanghai Oil was the signatory party, China Oil Company was the real controller. They were the real owner of the assets. They're the one who were financially benefiting from this entire project. So it is justified for my company to hold China Oil Company liable.
Honorable Tribunal, to support Ms. Akhtar's statement, I am drawing your attention to page number 4 of the statement of claim, where it is stated all the criteria which justifies lifting of corporate bail in sections 195, 197, and 199 of the Companies Act, 1994. As per Ms. Akhtar's statement, it is clearly shown all the acts of China Oil reveals that they are the real owners, they have the financial interest, and they hold the controlling power on the management of the company. Ms. Akhtar, do tell the tribunal the exit plan as per the PS agreement between BNOC and the China Oil Company to generate profit from the project.
As per the PS agreement, it was decided Shanghai Oil will be permitted to sell all production necessary to recover its costs. Afterwards, from the surplus, it will again get the major portion, which is 70%, and BNOC shall be entitled to receive the remaining 30% of the oil produced in excess of the cost.
I would like to draw the attention of the tribunal that this answer is substantiated in paragraph number 3 of the facts of the case. Thank you, Ms. Akhtar. Now the claimant would like to call Ms. Bushra Haq for direct examination of second witness.
Am I audible to the Honorable Tribunal?
Yes, Ms. Haq, you are.
Thank you.
I can hear you, my colleagues.
Honorable Chairman, may I interrupt?
Yeah, sure. Go ahead.
With your permission, may I cross-examine my witness, and then they can continue with the chief examination?
Yes, I was wondering what the process you have agreed or what the rules had set for you. But normally, after the direct examination of a witness in a real hearing, you would have the cross-examination. So for myself, speaking for myself, I would say yes. Let me just check with my colleagues as to what they think. Samir Sattar?
So I think it's a sensible idea to have the cross-examination now than later.
Margot?
Yes, sir. I'm of the same idea as well.
Okay. So
Thank
before we hear from Bushra, can we have the cross-examination of Shamima Akhtar? Okay, Mr. Bhattacharya, Charji, you comfortable with that?
Honorable Tribunal, was it directed to me?
I was speaking. Yes, I know. You are the witness for the claimant, right?
Correct. That is correct.
Yes. What we think we should do is that we should have the cross-examination of Shamima Akhtar before we get to your evidence. So can you wait for a little while? Okay.
Yes.
And so, counsel for the respondent, can you please start your cross-examination of Shamima Akhtar?
Honorable Chair and the respected arbitrators, with your permission, may I cross-examine?
Yes, please, go ahead.
Much obliged, Your Honor. Are you?
Learned counsel, you're not audible. Could you repeat the question?
Are you Shamima Akhtar?
I am Shamima Akhtar.
So Shamima, you are the director of the business operations, weren't you?
Yes, that is correct.
Since 1988 to 1999, you hold that position, right?
That is correct.
Are you still a part of Bangladesh National Oil Company?
As you can see, I have retired and my tenure was up till 1999.
Okay. So did you know about the processing of this type of projects?
Of course, since I'm the business director, I am required to know all the business operations of my company.
So you knew very well that how this kind of projects were run, right?
That's correct.
So tell me, did you get any mail from China Oil Company regarding the subsidiary company?
I did.
So did you reply to that mail?
I did.
So you agreed that Shanghai Oil to be the signatory party, right?
I was asked that it was required for China Oil to include a subsidiary. And then I was asking for a written guarantee, which they were unable to provide. And then they assured me that the relationship between BNOC shall not be hampered. So taking their good faith, I agreed upon what Mr. Nangchang had informed me.
Okay. So did you have proper knowledge with all the terms of the agreement?
I did.
So you knew very well that decommission is a big project, didn't you?
Of course.
So did you tell Kausar Ahmed that decommissioning is a part of the project initially?
It is an implied obligation, and we have had that production sharing agreement, which was for 20 years. So everything had been settled since the beginning, since the inception of signing the contracts.
So both of you knew very well that decommission is an expensive part, didn't you?
In general, it has a standard costing for decommissioning. Every project requires that after you have built an infrastructure, you're required to decommission, deplug. It's a standard procedure that every company is required to follow.
So why did you expressly excluded decommissioning from the agreement, and you were saying about the implied term?
I think if you listen, if you listen to the statement of the second witness, you'd be able to get a better idea, since he knows the in and outs of how decommissioning is. I am merely the business director, and I was just overseeing how the business operations in different countries operate.
So weren't you the part when the contract was made?
Yes.
So what is the approximate expense for decommissioning? Do you have any idea about that?
I did.
So what is the approximate expense?
We see that a profit of 350 USD was generated, and decommissioning requires 100 USD.
So
Learned Counsel, I think if you listen to the second witness and their testimony, you would be able to get a better idea of how the business, how the decommissioning process formalized.
no, you were the part of the company initially, so that is the reason I'm asking you about that. Anyway,
Of course, but we have a business, we have an decommissioning expert who would be able to give you a better overview of the entire process. I was the director of business operations, so
okay.
I had a holistic approach of how everything was running.
Was there anything written in the contract that China Oil will bear any kind of expenses?
China Oil was the effective, they had the effective control. They were the real controller, and they were also providing the employees, the assets, and all the profits that was generated from this entire project was also repatriated back to the bank account of China Oil, which was located in Hong Kong. So yes, China Oil is responsible for all the expenses, as you can see.
Okay. So wherein the drilling is supposed to be on the offshore according to the contract?
These are things that you would be able to know from the second witness. I implore you to cross-examine the second witness, who would be able to give you better overview of the entire process, like I've mentioned before.
Counsel, may I intervene as chairman? Obviously, this witness deals with the business operations, and she's not a technical person. So your technical questions must be reserved for the next witness, who is probably better able to deal with it. So we'll have to wait for those questions, for the answers to those questions. But anything to do with business operations, the contractual matters, please go ahead and ask your questions to this witness.
No, that's all, Honorable Chair and the arbitrators from my part.
Thank you very much. Okay, Mr. Bhattacharjee, any re-examination? Counsel for the claimant, do you have any re-examination of your witness?
Honorable Tribunal, now the claimant would like to call Ms. Bushra for direct examination of second witness.
All right, well then, wait a minute. Let me ask my colleagues whether they have any questions of this witness, okay, before you release this witness. Margot, do you have any questions?
No, sir, I have no questions here.
What about you, Samir?
Sir, I just have one particular question, and to the witness, the business development officer.
Yes.
When the party was substituted to be Shanghai Oil, and in relation to the payments that were going to be made to another entity, was this issue brought up before the contract was signed, or was this clarified there? What are your observations on this thought? To the witness.
Ms. Akhtar, are you still there?
I am. I could not hear the question.
All right.
Can
Of course.
you repeat the
Samir,
question?
can you please go again?
Yes, sir. So basically, in relation to when the contracting party was changed at the last minute, however, we note that the payments were made directly to another party. Was this arrangement something that was discussed prior to the contract was made, and was this a clarified position?
Yes, it was a pre-arrangement. I was notified through email, and I communicated with the project leader, Mr. Chengdu Nangchang, of the China Oil company, not Shanghai Oil, which is the parent company, the operator of the entire project.
Thank you.
Yeah, I have one question of this witness, which is in relation to the response that you got from the China from China National Oil Corporation, which is, you said that they were not able to get a guarantee. You asked for a performance guarantee, and you said that they were not able to get a performance guarantee from their predecessors, sorry, from their seniors. But what they have said that the relationship with China National Oil Corporation will remain. Is that what you said?
That was what they said from their end. And we understood that it is a display of good faith from their part. And so we relied upon their statement and took that into consideration.
Yes. So following that, you continued to do business with the Shanghai Oil Corporation. Is that correct?
We did.
Right. But would that be on the basis that you, as you said, they made a good faith assertion that the relationship would not be affected, and therefore, at the back of your mind, you were confident that China National Oil Corporation, was involved with this project?
We held consultations with our team, and we found it fit to continue because China Oil proved that there was diligence and good faith from their part.
Okay. Thank you very much. I have no further questions.
Sir, I just have a follow-on to that.
Okay.
Just a small one. Did you, to the witness, did you receive any performance guarantee from Shanghai, the company, the subsidiary, afterwards?
We did not. They were merely a contractor, and they were operating based on the directions they were getting from China Oil. So our whole communication was with China Oil, not Shanghai Oil.
So when China Oil did not give that guarantee, you did not seek a guarantee from Shanghai. Is that correct?
That is correct.
Okay.
Thank you. Do any of the counsel who are involved have any questions as a result of the tribunal's questions? Mr. Bhattacharya?
Honorable Tribunal.
Do you have any questions?
Am I audible?
Yes, you are. Do you have any questions arising out of the tribunal's questions?
I have no question. Now the claimant would like to call Ms. Bushra for direct examination of second witness.
Okay.
Honorable Tribunal, if you please permit me, I would like to start the direct examinations of the second witness.
Right.
May I? Thank you. Am I audible to you, the second witness?
Yes.
Please state your name for the record.
My name is Kausar Ahmed.
What is your role at Bangladesh National Oil Company?
I'm the Director of Legal Affairs at Bangladesh National Oil Company.
Could you please tell us about the production sharing agreement and operating agreement Bangladesh National Oil Company had with China Oil?
China Oil Company, through its subsidiary Shanghai Oil, signed a 20-year production sharing agreement and operating agreement with Bangladesh National Oil Company to operate offshore oil wells. The agreement reached its tenure in December 2012.
What happened after the expiry of this agreement?
On 3rd January 2013, I had emailed Mr. Chengdu Nanchang, the project leader of China Oil in Bangladesh, of the company's obligation to decommission and plug the oil wells. I also reminded him of the standards of decommissioning and plugging that has to be followed.
Honorable Tribunal, at this point, I would like to draw your attention to the exhibit number 3 by the claimant, which shows that Mr. Kausar Ahmed did indeed send an email to Mr. Chengdu Nanchang, reminding him of China Oil's obligation for decommissioning and plugging.
Can you remind me what's the exhibit number?
Exhibit number 3.
Thank you.
Thank you, Honorable Tribunal. Mr. Ahmed, back to you. What did Mr. Nanchang reply?
Mr. Nanchang replied to me a few days later, stating that the estimates show that the decommissioning and plugging would cost $100 million US, and that China Oil not only denies to decommission and plug the well, but also denies to pay any cost of decommissioning and plugging.
Honorable Tribunal, I'm drawing your attention again to paragraph 15 of the case, which supports that this statement, China Well did indeed refuse to decommission and plug the wells. Back to you again, Mr. Ahmed. Given that there was no express provision as regards to decommission and plugging in the production sharing agreement or the operating agreement, why has BUNOC still asked China Well to undertake decommissioning and plugging?
The specific obligation of decommissioning and plugging, even in its absence in the agreement, have to be read in the light of the more general duty placed upon licensees or operators to execute all operations in or in connection with the licensed area in a proper and workmanlike manner, in accordance with the methods and practice customarily used in good oil field practice.
In the present day contracts usually include provisions for decommission and plugging. Then why wasn't this mentioned in this contract?
You have to see that this contract was executed in late 1991 and came into effect in 1992. Most contractual agreements back then in the oil and gas industry did not contain any express provision regarding decommissioning or plugging till almost the end of the 20th century. Host governments only mandated that contractors carry out undefined measures appropriate to good oil field practice.
Mr. Ahmed, you have mentioned about the term good oil field practice. Do the laws of Bangladesh require petroleum companies to carry out good oil field practice?
Yes, the Bangladesh Petroleum Act 1974 mandates that petroleum operations be carried under good oil field practices.
Does anything in the agreements imply that China Well has to undertake decommissioning and plugging?
According to the PS agreement, which is in the nature of sole risk, China Oil took all the risk and costs relating to an oil field. This implies that they have to bear the cost of decommissioning. Moreover, the PS agreement and the operating agreement both provide a clause for good and faithful performance of its obligations under the respective agreements for China Oil Company's subsidiary, Shanghai Oil.
Does international practice of the petroleum industry dictate that it is China Well that must undertake the duties of decommissioning?
Yes, every operator or foreign state-owned company has to allocate money for decommissioning in its budget of the work program. It is the practice of the international petroleum industry, which is called Lex Petrolia, that a foreign company which explores oil or gas has to pay also for decommissioning. International practice suggests that the operator will bear all costs of operation of petroleum fields, including decommissioning.
To your knowledge, did China Well have a plan regarding decommissioning or plugging the wells?
The Bangladesh Environment Conservation Rules 1997 mandates projects which require a red category clearance, which this was, have a rehabilitation and relocation plan. Now, red category projects require an environment clearance certificate every year. This means China Oil, in order to get the clearance certificate for the last since 1997 of this project, have had to submit a decommissioning and plugging to get an environment clearance.
At this point, I would like to draw the attention of the Honorable Tribunal again to the exhibit number 7, which is the Bangladesh Environment Conservation Rules 1997. What our witness is referring to are rules 6, 7, and 8 of this rule. This statement is also asserted in page number 7 of our statement of claim. Mr. Ahmed, back to you again. You have mentioned environmental regulations in this regard. Can you state any correlation between the petroleum laws and the practices and environmental guidelines?
The Bangladesh Petroleum Act 1974 requires operators to take into account factors of environment and ecology. Petroleum operations have a long-lasting impact on the environment. Hence, good oil field practice and the protection of environment and ecology would obviously suggest decommissioning and plugging.
Can you cite an example where there was no express provisions of decommissioning and plugging? and yet environmental regulations mandate it?
Yes, in Nigeria, the petroleum laws contain no express reference to decommissioning and plugging. So their petroleum ministry has mandated decommissioning and plugging under the environment regulations of their country.
Mr. Ahmed, China has estimated that the standards of decommissioning and plugging set by you would cost them 100. Mr. Ahmed?
Yes, I got your question now. Although till now, no country has been able to actually find an exact cost to decommissioning and plugging, but in most cases, the cost usually crosses 100 million US dollars. Whereas in this case, the standards set by us, which are in conformity with the environmental regulations of the country, and the estimate done by them shows it costs only 100 million US dollars.
Can you refer some examples where the cost of decommissioning crossed 100 million US dollar?
If we look at the example of the Bullwinkle or Pompano platform decommissioning, the Bullwinkle platform costed 256 million US dollars, and Pompano costed 205 million US dollars in the Gulf of Mexico.
Can you please say why shall we consider what other decommissioning and plugging projects in other countries have costed?
All decommissioning and plugging procedure is similar in nature. It is a 10-stage process. So taking into account costs of decommissioning and plugging projects in other countries is a good indicator as to why the estimated value in this case is reasonable.
Do you hold the estimated value of US dollar 100 million as reasonable?
Yes, it is very reasonable if we compare it to decommissioning projects in other states. On top of that, BNSC has agreed to share the costs with China Oil in the ratio of 70:30 because we want to settle this dispute amicably.
Thank you, Mr. Ahmed. That's all for you. Honorable Tribunal, we would humbly submit the exhibit number 5, which states the usual cost of decommissioning and plugging. And now, at this point, I don't have any further questions to the claimant witness. If the respondent wants, they can cross-examine the witness.
Yes, I think this is the time for the respondent to cross-examine. Who's going to be cross-examining on behalf of the respondents?
Honorable Chair and arbitrators of arbitration panel, may I have your permission to proceed?
Yes, you are counsel for the respondent. You want to cross-examine Mr. Kausar Ahmed, right?
Yes, sir.
Please go ahead.
Thank you. Mr. Kausar Ahmed, the agreement took place on 1991, right?
Yes.
Did you show to the tribunal any instance where decommissioning was not included, but the party had to bear responsibility?
Yes, we did tell about the example in Nigeria that there are no express provision in their petroleum laws or even till now in their production sharing agreements, but environment regulations mandate that decommissioning must be taken.
You drafted the agreement, am I correct?
I was not in BNSC at that time. It was drafted in the negotiations between the claimant and the respondent back then.
You are the director of legal affairs, am I correct?
Yes, I am, but I was not back then.
The agreement ended on December 2012, is that correct?
Yes.
On 2 January 2013, you emailed Mr. Chengdu Nangchang about decommissioning, is that right?
Yes.
As the director of legal affairs, you were supposed to draft the agreement, am I correct?
But I was not an employee of BNSC back then in 1991. I joined BNSC later on.
Okay. China Oil Company's obligation were to explore, produce, and drill the oil wells. Is it right?
In the agreement, yes.
There was only one agreement. Am I correct?
No, there were two actually, a production sharing agreement and an operating agreement.
So in that agreement, you did not mention about anything for decommissioning. Am I correct?
We did not have to mention anything for decommissioning because it was an implied obligation.
Decommissioning cost is 100 USD. Am I right?
According to your estimates, yes, it does cost 100 million US dollars.
As it was not in the agreement and costs a vast amount, BNOC would pay that, correct?
No, because it was an implied obligation that China Oil, as the main profiteer of this arrangement, would bear the decommissioning cost. In the interest of settling this dispute amicably, we are saying we would share the cost in 70:30 ratio.
Did you have any previous implied terms where it happened that someone had decommissioned after doing the producing oil wells?
All the oil and gas installations in Bangladesh run by foreign companies have to provide a decommissioning plan, which China Oil did, because under the environment conservation rules, they are bound to. Otherwise, your license would not have been renewed since 1997.
The agreement says that China Oil company will be bound by the previous law of Bangladesh. Am I correct?
The agreement stated that China Oil would be bound by the applicable laws of Bangladesh.
And if any changes came after that, China Oil company will not be bound by that. Is that correct?
It only talks about changes in economics, not in other aspects.
Okay, moving on to further questions. You got an email from Chengdu Nangchang mentioning about a subsidiary company to appoint. Am I correct?
Yes.
Did they mention why they appoint a subsidiary company?
They said it was an internal corporate necessity and that it would not affect the relation between China Oil or Bangladesh National Oil Company.
What was your understanding about the subsidiary company being appointed?
Counsel, these questions were supposed to be asked to the first witness because they dealt with it. They were the business operation director. I was not back then, but Chengdu Nanchang did provide oral guarantee that it would not affect the relation, a written guarantee in their email when they failed to give a written performance. And not only that, all the dealings that were actually done with Shanghai Oil was through the capital and employees provided by China Oil. Shanghai Oil is just a mere entity on paper.
BNOC did not complain anything about the subsidiary company. Am I correct?
No, it did not, because you provided the guarantee that it would not affect any relation between BNOC and China Oil.
Honorable arbitrators, I would like to suggest that BNOC knew that a subsidiary company is going to be appointed and all the responsibility will be borne by the subsidiary company. And Mr. Kausar Ahmed very much knew about the decommissioning is a huge task. A separate agreement is needed. For that reason, Mr. Kausar Ahmed had no intention to mention the decommissioning into the agreement. Moving on to further question. Don't you think there should have an express term as it was project between two countries?
It was not a project between two countries. BNOC has waived all its sovereign immunities. If you check the fact of the case, hence it was not a project between two countries, but two companies.
Later on, China Oil found that the drill beyond the continental shelf, what was contrary to BNOC was representing. Wasn't it misleading?
No, it was not misleading. Rather, it was a mistake of fact, because back then, it was also China's obligation to see the area they were drilling, was it in Bangladesh's territory? And the conflict that arose regarding the territory, that didn't start that judgment came after 2012, the tenure of the agreement. Now China Oil cannot say that after taking all the oil that that area is not yours, so we don't have any obligation there.
Do you have any discussion while preparing the agreement with Shanghai Oil?
I have told you again, I was not an employee back then at BNOC.
So the misrepresentation of the continental shelf.
A mistake of fact, not
Sorry.
misrepresentation.
Okay, no further question asked, honorable arbitrators and honorable chairman.
Thank you very much. Let me see if my colleagues have any questions. Mr. Samir Sattar, do you have any questions?
Yes, sir. Yes, I do actually. A specific question to the witness. I understand that you were not there at the time when the contract was drafted and was entered into, but you are working now there. Is that correct?
Yes, honorable member.
Yes. Is there any particular reason why the claim is going straight after China Oil as opposed to Shanghai Oil? Should you not have made Shanghai Oil a party as well?
Honorable Tribunal.
As the primary contractor?
Yes, Honorable Tribunal, if we look at the facts of the case, it is clearly mentioned that all the capitals and liabilities of Shanghai Oil were provided by China Oil. Shanghai Oil on its own, besides being an entity on paper, has nothing of its own. First. Secondly, China Oil, before this arbitration proceeding, when we emailed them regarding decommissioning, they never referred Shanghai Oil. They always talk in the terms of being China Oil, its own liabilities and its own responsibilities.
So any communication between you regarding the decommissioning has always been with China Oil, is that what you're saying? Or has there been any communication with Shanghai Oil as well?
It has always been with Chengdu Nanchang, who's the project leader of China Oil, and he oversees everything regarding this project.
Okay, thank you very much. No further questions from my side, sir.
Thank you. Mr. Margoob Kabir, do you have any questions?
Yes, sir. I have just one or two questions to the witness. So
Yes,
basically,
please.
you were referring to the environmental regulation of Nigeria.
Yes, sir.
Sorry, am I audible?
Yeah, yes, Honorable Tribunal.
So you referred to the environmental regulations of Nigeria being, making it, even though it's not in the contract, making, saying that, it's compulsory in a way because it's included in the regulation. Is that something similar is included in Bangladesh as well?
Yes, it is also included in the Environment Conservation Act as well as the Environment Conservation Rules, as our council has stated in the claimant exhibit number 5, which shows rules 6, 7, and 8 of the Environment Conservation Rules 1997. It mandates that under environment regulations, they have to have a rehabilitation and relocation plan. Now, what does rehabilitation means? It means to return the area to its former stage, and relocation means to remove the present installations there. So China Oil would not have received a license from the Department of Environment if they did not have a plan thereof.
Okay, are you aware of whether, the submissions that they had made in the environmental department, that they did actually submit a decommissioning plan? Are you aware of that? Or are you assuming that they did?
We are not assuming that they submitted, but they had to submit it. Otherwise, their license would have been cancelled way back then.
So you know for a fact that they did submit a decommissioning plan?
They had to, Honorable Tribunal.
Are you not understanding my question? I said, do you know for a fact that they did submit?
Yes, for a fact, we know they submitted.
Okay. Last thing which I wanted to know, in the recent contract, as you are the director of legal, do you include decommissioning as part of the contract?
In the last model production sharing contract of Bangladesh, that's the been drafted in 2008, there is a separate plan for abandonment and the provisions that are followed worldwide.
So there's a specific decommissioning.
Under the contracts after 2008, yes.
Okay. No further questions, Mr. Chairman.
Thank you, Mr. Kabir. Mr. Ahmed, I have a few questions. First of all, the original agreement that Bangladesh National Oil Corporation entered into with the China Oil Corporation, has there been, who were the parties? The parties were Bangladesh National Oil Corporation and China Oil Corporation. Is that correct? The original agreement that you had in respect of the production sharing and the operations agreements.
Honorable Chair, the contract was negotiated by Bangladesh National Oil Company and China Oil Company, but at the last moment, as China Oil Company stated, it was an internal corporate necessity. They had to make Shanghai Oil Company incorporated in Bangladesh to be the signatory.
But was there any separate agreement made with Shanghai Oil Company?
No, Shanghai Oil was the signatory to it, Honorable Chairman, not a separate agreement.
Sorry, I don't understand the answer. My question is, as far as an agreement is concerned, there are two parties, right? So there's party A, party B. So the party A originally, when the contract was signed in 1991, was about the party A. The first party was Bangladesh Oil, okay? So entering into the production sharing agreement, and China Oil was the other party, party B, right?
No, Shanghai Oil was the signatory party, party B.
From 1991?
From 1992, yes, sir.
From 1992. So Shanghai Oil was a party to the agreement.
Yes, sir.
And what about China Oil? Was China Oil signatory to the agreement?
China Oil initially negotiated the agreement with Bangladesh National Oil Company. Okay. No, China Oil was not the signatory to the agreement. It was their subsidiary.
Right.
But China Oil and Shanghai Oil is a single entity.
When was the agreement entered into? Please remind me again. I'm just wanting to get the chronology right. The original agreement? It was
entered into in 1992, sir.
1992. And the signatory party to the agreement was Shanghai Oil in the 1992 agreement.
Yes, as a subsidiary of China Oil.
As a subsidiary of China Oil. Is China Oil mentioned in the agreement? I'll have to remind myself again by looking at it. You know, this is something we will look at when we are deliberating, obviously. But just to get an idea of the situation from you, is China Oil mentioned in the agreement at all?
No.
It's not. Okay. So it was the negotiating party. So they were all right. Next, the $100 million estimate in respect of decommissioning and plugging. Whose estimate is that?
It was China Oil's estimate.
Okay. And how did you get to know about it?
After the agreement reached its end in 2012, we had emailed China Oil's project leader to decommission and plug the wells. After a few days, their project leader, they emailed us back saying they would not decommission and plug the wells, and their estimated cost is $100 million US dollars.
Right. Okay. Fine. I understand that. The next question is, obviously, there was a license obtained for this project from the Department of Environment. Do you know who the license was issued to? Was it to China Oil or to Shanghai Oil?
It was issued to Shanghai Oil.
Right. And as far as the license conditions are concerned, was there anything in the license condition itself which provided for decommissioning and plugging?
The license used the words rehabilitation and relocation plan. Now, Honorable Tribunal, if we look at the meaning of rehabilitation relocation, it would obviously suggest that in terms of oil and gas installation, it means decommissioning and plugging.
Okay. And this environmental license was issued when?
It has been issued since 1997 after the formation of the route.
Okay. Thank you very much. I have no further questions, but do any of the counsel, either for the claimant or for the respondent, have any questions arising out of the tribunal's questions? Counsel for the claimant?
Honorable Tribunal, I don't have any question.
Okay, thank you. Counsel for the respondent?
No, Honorable Chairman, I don't have any further questions.
Thank you very much. Okay. So that completes the evidence for the claimant, does it? Counsel for the claimant? Is that your case? That's the end of your case?
Honorable Tribunal, that's all to do with the evidence and the examination of witnesses. If you would like to permit, Mr. Raihan would now proceed with the closing statement.
Well, we'll have the closing statement after the evidence from the respondents, right? Or do you want to have the closing statements now?
So we want to proceed after the respondent has submitted their submission.
Okay. Fine, but that will be only on the evidence that we have heard in from the claimant, right? We won't have, the submissions will not be complete because you will not be making submissions on the evidence that is given by the witnesses for the respondent.
Sir, we will proceed with the closing argument once the respondent has raised their witness and they have been cross-examined.
All right. Okay, that's fine. Thank you very much. I misunderstood you. All right. So then it's over to counsel for the respondent, right?
Honorable Chairman and the members tribunal, if you permit, now I would like to request Counsel Sumaya bin Yusuf to present the opening statement on behalf of the respondent.
Thank you very much.
Much obliged.
Good morning, Honorable Chairman and the respected arbitrators and my respected opponents. First of all, we are extremely sorry for a gross mistake by our team. Mistakenly, in the cover page of our submission, we put the names of the companies from our previous case. It was supposed to be China Oil Company and Bangladesh National Oil Company. And we are extremely sorry and extremely embarrassed. We did not do that intentionally. And we are sorry, Your Honor. With your permission, may I proceed?
Yes, please.
Much obliged, Your Honor. I, Sumaya bin Yusuf, the coordinator of the team BIAC Academy, Department of Law. The team represents respondent of China Oil Company, a state-owned corporation headquartered in Shanghai, was the successful bidder of one of the drilling oil concessions. We have got 6 counsels in our team. Muna Haq will be presenting opening statement and also playing a role of the witness. Nusha Jahan will be doing the examination in chief of the witness Chengru Nanchang. Baina Ifa is doing the examination in chief of our second witness Fungsung Wangru. Nuret Asin Arwa is doing the cross-examination of Kausar Ahmed. Sumaya Binti Yusuf is doing the cross-examination already did of Shamim Akhtar, and also she'll be playing the role of the other witness from the responding team. Ishtiaq bin Farooq will be presenting closing statement, and Baina Ifa is the moderator. And now, with your permission, I would request Muna Haq to present her opening statement.
Thank you very much, Ms. Haq.
Much obliged, Your Honor.
Your Honorable Chairman and the arbitrators, may I proceed?
Yes, please.
Much obliged. I am a counsel of the respondent, Muna Haq. Honorable Chairman and arbitrators, there was an inadvertent error which the claimant wrongly referred to as negligence. We were unable to send 2 exhibits. Exhibit 12, appointment letter of Mr. Mukhlisur Rahman, project head of Shanghai Oil Company, and Exhibit 13 of fax to Director of Legal Affairs of Bangladesh National Oil Company, Mr. Kausar Ahmed. May we get the permission to use them?
Have you given copies of these to the other side?
Honorable Chair.
Honorable Chairman, we beg to state that we have not received any copies of these two specific witness statements that they're talking about.
Well, we can't see anything, and we can't actually deal with any document which the other side have not seen. So, Ms.
We
Munahak,
have
will
sent
you
that to Runa, madam.
forgive me?
We have sent the docs to Runa, madam.
Oh, you have sent the documents to the tribunal secretary. Okay. In which case, we will have to make sure that counsel and the team for the claimant sees these two exhibits. I don't know, how can we manage this? Is anyone there from BIAC? Is there some way that you can send these documents over to the claimant side?
Honorable Chairman, if you permit, then I can show the exhibits by screen sharing.
By screen sharing, no, I think that
tribunal, we would like to object to this because we have not been given any prior notice about this, and we have not even taken time to even prepare about two sudden witnesses today coming to this honorable tribunal. Had we even known about these exhibits, or had they been even sent to us at least, or any prior notice even, we would have been able to prepare for these two witnesses, but this is happening all on a sudden, unfortunately.
Right. Let us try and understand what this goes to without actually going into the details of the documents. Obviously, we have to rule on whether we admit it or not. Okay, so perhaps you would listen to counsel for the respondent telling us what Exhibit 12 is and what Exhibit 13 is, without seeing them. And then if you have objections, we will hear your objections and we will rule one way or the other. Okay? Okay, counsel, please tell us, counsel for the respondent, Munahak, please tell us what Exhibit 12 is.
The Exhibit 12 is an appointment letter of Mr. Mukhlesur Rahman as the new project head of Shanghai Oil Company. And Exhibit 13 is a fax to Director of Legal Affairs of Bangladesh National Oil Company, Mr. Kausar Ahmed. If we don't get to use them, it is totally fine. I would like to proceed with my opening statement. If there are problems, then I will leave it.
Okay, tell us about the facts to Mr. Okay, tell us why Exhibit 12 is relevant, first of all.
Because Chendu was no more the head, and his work was transferred to Mukhlesur Rahman as the project head of Shanghai Oil Company. Back when we told that there would, when Shanghai Oil signed the agreement to the agreement, at that time, as the claimant showed the email, that there was a change all of a sudden, like they said. It was not, because we transferred our work to Mr. Mukhlesur Rahman as the project head of Shanghai Oil. So we, China Oil, we were not in the agreement.
Okay. And Exhibit 13, the fax that was sent to Mr. Kausar Ahmed, what was it? What was this? And when was this sent?
It was sent after the contract ended. It was sent to him that we were unable to do decommissioning.
Okay. Right. Let me just speak to my colleagues and see what they have to say. Samir, have you got any thoughts on this?
Yes, sir. I think we, without giving an opportunity to the claimant to see the witness statements, unless you think that it is absolutely necessary on the issues to be decided, I think it should not be allowed. That's my personal opinion.
Okay, Margot?
While I agree with what Mr. Sattar said, but I think it may be essential as to the merit. So regarding the change, the appointment of Mr. Mukhlisur Rahman, if this was a communication which was shared with the claimant and they were aware of it, and still they're basing their case on, for example, the other individual being, sending the facts. So I think in that regard, it may be essential to know whether they were aware of the fact that there was a change. And regarding the second one about the facts which was sent, I think it was already discussed during the
evidence,
the
yes,
process as well. So maybe that was already been introduced in some manner.
And also, I think as counsel for the respondent has said that she is quite content to proceed without those documents, on that basis. And I personally think it's going to be unfair to allow any document to come in at the last stage. And also, when the other side have not seen the document. Okay, so that is a very important thing. We have to deal with issues fairly, and I personally don't think, and I'm sure you would agree with me, my colleagues, that it would not be fair to allow any document to be introduced which has not been seen by the other side, by the claimant. So that's the first thing. And secondly, because Ms. Hock says that she is happy to proceed without them, I would also agree with you and say not at this stage. But let us see how we proceed. If Exhibit 12 becomes relevant during the course of the hearing, then we may reconsider our position. But as far as Exhibit 13 is concerned, I can't see any need for it, because as far as China Oil is concerned, they have said we're not going to do the decommissioning anyway. So that's a statement which has come through the evidence anyway. So I don't think it really assists the tribunal one way or the other, because the issue that we have to decide is who is responsible for decommissioning and plugging. So on that basis, Ms. Hock, for the moment, we're not going to allow you to bring in Exhibit 13. As far as Exhibit 12 is concerned, we may reconsider, but that is subject to the claimant having sight of it and subject to our considering it necessary later on. Let us proceed without them for the moment. Thank you.
Thank you, Honorable Chairman and Tribunal. This case is all about what is not in the agreement. It is about imposing duties that do not exist. But before I dive into the arguments of terms of contract, obligations, and laws of Bangladesh in accordance with the arbitration clause, it is necessary to focus on the separate legal entity of a company. The agreement in 1991 was signed between Shanghai Oil and Bangladesh National Oil Company. It was Shanghai Oil and not China Oil who was party to the agreement, like the claimant agreed. According to Salmon and Salmon, a company has a separate entity. Thus, Shanghai Oil's responsibilities are theirs and not ours. However, there are several claims we must refute since we are the respondent in this dispute after all. In December 2012, the contract between Shanghai Oil and Bangladesh National Oil Company ended. The contractual relationship between the two companies seemed to have ended on a good note until Bangladesh National Oil Company requested for decommissioning after the contract had ended. We sent them an email saying that it was not possible, but we did not get any reply. Your Honor, may I refer to Exhibit number 1, the email?
Yes.
Coordinator Baina, can we show the email?
Email or exhibit number 1?
The email. I think that is exhibit number 1.
Yeah, sure.
Can we get a closer look, please?
Sure.
Yeah. Yes, please. It is clearly stated in this email that we were unable to do any decommissioning or plugging the oils because there had to be a separate agreement, which we never had. I would like to go back to my opening statement again. So it is now important to discuss the reasons why decommissioning was not possible. I would like to begin with the issues regarding express term of contract. The claimant pointed out an express term from the contract, that is, Shanghai Oil will bear the risks of exploration. They contended that this could be an authority to support decommissioning. This is incorrect because the word exploration cannot be interpreted to include decommissioning, a process after the completion of the production. If we simply Google search exploration, we will find a Wikipedia link where exploration is defined as the search by petroleum geologists and geophysicists for deposits of hydrocarbons, particularly petroleum and natural gas. With that being said, there were no terms such as decommissioning, removal, or abandonment in our contract. For this, I would like to refer to the Arbitration Tribunal to Exhibit 2, Deed of Agreement, submitted by us to the claimants. We did not even have any oral conversation about decommissioning. Yes, we admit that the oil well was no longer suitable for the extraction towards the end of the contract. However, that did not trigger the necessity to decommissioning. The claimant's reference to good oil field practice is appropriate for the standards of exploration and production that is during the performance of the contract. It does not, however, point out to decommissioning, which is a process after exploration and production. There is no convincing reason behind why we should interpret good oil field practice to include decommissioning. Only because some international companies do is not enough of a reason for us. Moving on to the arguments of implied terms regarding the laws of Bangladesh. It is possible that an implied term could be present in a contract, any contract. However, there has to be a law in order to incorporate the implied term, and this would not require parties' intentions because an obligation would be imposed on the parties. As Lord Denning stated in Shell UK Limited and Lobstock Garages Limited 1976, that if the parties' intentions are not found regarding terms of a contract, then the dispute would have to be solved by asking, has the law already defined the obligation or the extent to it? If so, let it be followed. If we think for a second that there is an implied term of decommissioning, we cannot point out a Bangladeshi law to impose it, like the Petroleum Act of 1998 of the United Kingdom, which regulates decommissioning. We also bring the example of the Brent field decommissioning. This field was situated in the UK's continental shelf in the North Sea. It is clearly stated on Shell's UK website, www.shell.co.uk/sustainability/decommissioning, that decommissioning in the UK's continental shelf follows a mature, tightly defined regulatory process that is stipulated in the UK's Petroleum Act 1998. There is no such law in Bangladesh whatsoever. What Bangladesh does have are laws regarding exploration and production, but not decommissioning specifically. For instance, Section 6 of the Petroleum Act 1974 enlisted the duties of persons involved in exploration, not decommissioning. As far as the environment is concerned, we have always followed all the criteria under Section 12 of Bangladesh Environmental Conservation Act 1995 and Rule 6 of Bangladesh Environmental Conservation Rule 1997. Hence, we got our environmental clearance certificate renewed every year. Again, this concern for the environment was relevant during exploration and production. Or in other words, relocation rehabilitation cannot be construed to include decommissioning. One cannot say out of nowhere that complying with those provisions inevitably creates an obligation to decommissioning. Besides, the companies that carry out decommissioning actually sign separate deeds, something explicit enough, which would not require discussions like we are engaged in today. The cost of this process is sky high. A $100 million process cannot be imposed on a party through implied terms. May I refer to Exhibit 11 of our submission, a photo of an oil field falling down by Naifa?
Yes, sure.
As you can see from the photo, that the oil field is falling off. Decommissioning is a delicate process and the oil rigs weigh thousands of tons. If not careful, accidents may occur that can pollute the water. It is this being careful which is very expensive and needs tight regulations that can only be articulated through legal framework. As the claimant said, there were no developed laws back then. Just because Nigeria carries out decommissioning despite implied obligation, it does not oblige Bangladesh to do the same. Now we turn to the agreement of international laws, whether they bind us or not. Aoife, can we turn the screen back? Yeah,
Yes, sure.
The claimant also argued that the obligation of decommissioning was imposed by international laws such as the United Nations Convention on the Laws of Seas. By signing the treaty would only oblige a country to take the relevant provisions into account without being bound to follow. Article 60 of the Convention on the Laws of Seas stated that the rights and authority of the coastal states were the rights and authority of the coastal states were. Therefore, even though Article 60 sub-Article 3 of the Convention talked about removal of installations, it would be coastal states' responsibility to do so. We also have International Maritime Organization Resolution A672/16 to support the fact that it is the coastal states' responsibility to decommission, like the claimants themselves did on their statement of claim, page 8 at paragraph 3. Additionally, the provision also stated at paragraph 3.5, where the cost is high, the state can decide to keep the installations untouched. Another noteworthy aspect of the IMO resolution is that installations set up in 1998 or after 1998 must be removed or decommissioned, as it has been stated at paragraph 3.2. All abandoned or disused installations or structures emplaced on the seabed on or after 1st January 1998 should be entirely removed. It was 1991 when Shanghai Oil set up the oil rig. Therefore, not only the claimants was unable to point out this express provision, they also missed the provision of IMO which they themselves cited. In a nutshell, Shanghai Oil or China Oil is not obliged to carry out decommissioning because there is no express agreement before or during the performance of the contract term. There are no national statutes which explicitly define decommissioning and how that can be regulated. On top of that, international laws impose decommissioning responsibilities on the coastal state, which in this case is Bangladesh. Since we are not entitled to decommission, we are not obliged to pay for it. That's all, Honorable Chair and Tribunal. Is there any question?
Thank you very much. None from me at the moment, but I'll ask my colleague, Samir Sattar, do you have any questions?
I'm fine for the moment, sir.
Okay. What about Mahbub Kabir?
I just have one question, sir. I just wanted to ask, when you say that the responsibility is usually on the coastal state
Yes.
for decommissioning, is there an express provision somewhere where it says that you're relying upon?
Yes, sir. The IMO provision A600, A672/16 document itself talked about all of the coastal states' responsibilities.
Okay, and secondly, do you, for example, as a company, do you enter into separate decommissioning plan when it comes to requirement of a decommissioning, or is it usually included in the contract itself?
No, sir, it is never included in one contract. We would need a separate deed because it's a high cost contract.
Okay, so I have no further questions.
Now, I would like to request Counsel Nusrat Jahan to chief examine our one of the witness Chang Dun and Chang.
Okay, please go ahead.
If you permit, may I examine my witness, who is the project leader, Mr. Chang Dun and Chang.
Yes,
Am I
please start.
hearable? Much obliged. Can you please tell your name for the record?
I am Chengdu Nanchang.
Can you please tell us why you are here today?
I am here today because there was a dispute between China Oil, which is a state-owned corporation, and BIAC, which is Bangladesh National Oil Company.
Who were the parties of the agreement?
The parties in this agreement were Shanghai Oil Company and Bangladesh National Oil Company.
What is your position in China Oil Company?
I am the project leader of China Oil Company, Bangladesh.
So what is your position in Shanghai Oil Company?
I signed the contract, but I do not hold any position over there.
Is Shanghai Oil Company the parent company?
No, it is the subsidiary company of China Oil Company.
Can you please tell us why there was a need of a subsidiary company?
As I am the project leader of China Oil Company, I have to deal with several issues. I will not be able to deal with that particular project competently. So this is why we plan to appoint someone who is very familiar with the Bangladeshi laws and regulations and circumstances.
Whom did you appoint for the project?
Mr. Muklesur Rahman has been appointed for the project.
Now I would like to request Council Bayana Ifa to show the exhibit number 13 by screen sharing.
Sure, wait a minute.
Which exhibit are you talking about?
Exhibit number 13, where the appointment letter is given.
Honorable Tribunal, we have raised questions regarding exhibit number 13.
Yeah, exactly. We have, in fact, exhibit number 12 and 13. We have said that we will be not looking at them at this point in time. Ms. Muna Haq, counsel who opened the case, she said that she was comfortable to proceed without them. And also, you know, in respect of exhibit 12, the appointment letter of Mr. Muklesur Rahman, we have reserved our position, but at the moment, I don't think we can look at them because the other side has not looked at them. Okay, so that's what the tribunal has ruled. So you'll have to proceed without these two exhibits, exhibits 12 and 13.
Okay, so there's no problem. Thank you. May I proceed now?
Yes, please, but without exhibits 12 and 13.
Okay.
Okay.
So what was BNOC's response about the subsidiary company?
A fax was been sent by the director of the business operation where it was stated that they have talked with the senior management and they agreed that Shanghai Oil shall be the signatory party instead of China Oil.
Can you please tell us how many projects you were dealing with in Bangladesh?
3-4 other projects apart from that.
What was the agreement about?
In 1990, the Ministry of Resources and Exploration invited bids from international oil companies for the opportunity to build oil concessions to explore, drill, and produce oil.
What was the time period of the contract?
There was a negotiation of 20-year production sharing contract and a cooperating agreement.
What was the responsibilities of Shanghai Oil Company under the agreement?
As there were the subsidiary parties, so their work was to look after the work and the performance of the contract without any disturbance.
Did you sign the agreement on 1992?
Yes, I have signed the agreement.
Why did you sign that agreement?
As the employees were from the China Oil and also the capitals were provided by them. So as a trustable person and being the leader of the project, I got instruction to sign the agreement on behalf of Shanghai Oil. After that, I appointed the head of the Shanghai Oil Company to look after the work.
Did you run the project?
No, I didn't.
Who ran the project?
The initial project was China Oil's, but then it was run by Shanghai Oil Company.
Can you please tell us why didn't you run the project?
As I've said, I was already dealing with other projects, so it was not possible for me to look after this project.
How did you inform about this to BNOC?
Through facts where I have mentioned that we have appointed someone as the head of Shanghai Oil.
To whom you make the facts?
To Mr. Kausar Ahmed.
Are you conversant with all the terms of the agreement?
Yes.
When did they ask for decommissioning and were there anything written about the decommissioning in the agreement?
They asked for decommissioning when they found out the offshore field reached the stage at which production was no longer commercially reasonable. So there was no express term on decommissioning on the agreement.
How did BNOC inform you about the decommissioning?
Through mail, they have informed us.
What written procedure did BNOC follow about decommissioning?
Apart from the mail, there was nothing in written form about the decommissioning as far as I remember.
When did Mr. Kausar Ahmed email you for the decommissioning?
They mailed us on 2013 after the expiration of the contract, as the time was till 2012 according to the contract.
What was your reply to that?
We refused, as there was nothing expressly written about that. Why would we agree with them?
Why did you refuse them for decommissioning?
As I've said, that there was nothing in the contract, so China Oil are not bound to pay. And also they asked for the decommissioning after the expiration. So the China Oil is not bound to pay for that.
Can you please tell us what was the cost of the decommissioning?
It was USD 100 million, and the cost is too much for Shanghai Oil.
What were the tasks you finished under the agreement?
We were supposed to drill, Shanghai Oil was supposed to drill and explore oil, which we did as written in the contract.
Why did Shanghai Oil Company drill for oil?
They drilled beyond the continental shelf and exclusive economic zone of Bangladesh, as it was supposed to be drilled on the continental shelf, but it was contrary to what BIAC has represented.
Was anything undone according to the agreement?
No, according to the agreement, there was nothing undone. We did everything without breaching any terms.
Can you please tell when the contract ended?
The contract ended in 2012.
When the performance by Shanghai Oil Company ended then?
It was also ended according to the time of the contract.
Thank you, that is all.
Right. Counsel for the claimant to cross-examine.
Honorable Tribunal, may I now cross-examine Mr. Chendu Nangchang?
Yes, please. Go ahead.
All right. Thank you so much. Mr. Nangchang, you mentioned in your statement that you just now in the direct examination, you stated that you signed the agreement on behalf of Shanghai Oil, but in your witness statement, you say you are an employee of China Oil.
I am the project leader of China Oil, and when I signed the agreement as a trustable person, which was on behalf of Shanghai Oil.
Yes, however, you are employed and that is you're working just for China Oil and not for Shanghai Oil.
As you have mentioned that Shanghai is the subsidiary company of China Oil. So I think it's obvious for me to be a part of Shanghai Oil, right?
That means, and as per the fact, Shanghai Oil did not have any employees and assets, correct?
No.
And China Oil provided Shanghai Oil all these assets and employees?
Yes, they did.
Mr. Nangchang, you say that you were not able to deal with the agreement or deal with this arrangement competitively, and that is why you decided to hand it over to Shanghai Oil to deal as the contractor in this agreement, right?
Yeah.
Just in your, all right. Then, Mr. Nangchang, why did you from China Oil negotiate everything, and our clients negotiated it with you as well, and then at the last minute,
See, China Oil was not able to look after all the work that was done in Bangladesh. So they appointed the subsidiary company, which is Shanghai, incorporated in Bangladesh, to look after all the work and to look after the performance to be done properly without any disturbance.
We agree that you have a lot of work to deal with, and that is not a problem for us. But why did you not disclose this earlier? Rather, the fact says in para 2 at the very last minute.
At first, we thought it wasn't necessary, but then with the amount of work, we had to inform you about the about the company at the last moment.
You said that it was not necessary, but Mr. Nanchang, one party is being substituted by another, and China Oil is not signing the agreement. You did not think this was necessary to inform my client earlier, rather at the last minute when we had no other option but to sign it with you.
If you guys wanted, you could have declined that, but you agreed. So there should not be any issue with that, right?
Mr. Nanchang, sorry, from my end, the internet just went off. My question to you again is, you said that this was at the last moment you realized this, and this was not important, but you are substituting one party with another and thereby giving the liabilities all to Shanghai Oil, and you still thought it was okay to mention this at the very last minute.
See, we didn't give all the liabilities to Shanghai. Shanghai didn't breach any contractual terms. If they would have, then we would have, given all the liabilities to them. But they didn't. So we never throw any liabilities on Shanghai Oil. So you can't say that.
It's not about throwing liabilities, Mr. Nanchang. When you substitute one party by another, all obligations, liabilities, and even rights are then given to that other party. So it seems that the very last minute, these rights were given. However, Mr. Nanchang, then let me please ask you this question, that why did you fail to get a written guarantee from the Chinese leaders then?
I asked them about it, but they could not provide it. So at the last moment, I was also unable to provide them with the written guarantee.
You say that they failed to give the written guarantee, and that has already been mentioned in the fact. Then is it true that the Chinese leaders did not want this arrangement and you went ahead with this either way?
There was Shanghai Oil, so they do not have to worry about anything. As being the subsidiary party, they were handling everything properly.
But Mr. Nanchang, it's not about handling properly or improperly. It's about substituting one party with another at the last minute without getting a written agreement, and then as you yourself signing it despite being a China Oil employee and signing it on behalf of Shanghai Oil. Does not that raise suspicion between the single entity of China Oil?
Why would? See, China Oil provided all the employees, as you guys have been saying it throughout the fact that China Oil provided all the capitals, all the employees. So signing on behalf of Shanghai Oil doesn't make any big issue with that, right? Because being a trustable person, they instructed me, and with the instruction, I signed the contract.
We have no written guarantee to verify your statement that they had actually given you the permission, and you stated you could not even provide us a guarantee.
BIAC agreed with that. So there is no problem with that. They agreed. So if they could have, declined that, but they didn't, right?
Because you see, BIAC agreed because at the end of the day, you said it would not harm the relation we had, and then and then you started repatriating all the profits to China Oil's account.
It didn't harm the contract. Did it harm the contract? No.
The question is not about harming the contract. The question is about whether BIAC is actually performing all obligations with China Oil. You as an employee of China Oil signed it, and then you are claiming you signed it on behalf of Shanghai Oil. Don't you see that the single entity here is only one company, that is China Oil Corporation Limited?
The project was initially with China Oil, but signing on behalf of Shanghai Oil doesn't make any difference. When I signed it, I was a party of the Shanghai Oil, but later on, I appointed someone else for that.
So that means at that point, you agree that you were also posing as a party and as someone from Shanghai Oil in your direct examination. All right, that's a point to be noted, Honorable Tribunal. Mr. Nanchang, I apologize again. Mr. Nanchang, when did you get to know about this dispute?
What dispute?
That BNOC is going ahead with an arbitration proceeding with to BIAC?
After they ask for the decommissioning, which is after the extension of the contract.
All right. So, Mr. Nanchang, we want to tell you that you in your direct examination stated that there was no subsequent fax or email received, and we suddenly came up with this arbitration proceeding. But are you aware of fact paragraph 10, which states if there is any dispute or if anyone wants to raise any dispute, even since you signed the agreement, they can surely approach the BIAC Arbitration Tribunal?
Yes, You can approach, but was there any problem? There was not any problem. You asked for the decommissioning and we disagreed with that. After that, you went to the arbitration tribunal. So it was not due to any kind of dispute between the two companies.
That is for the arbitration tribunal to decide, Mr. Nanchang. And then I would also like to ask you another thing. Did you get to see the written statement that China Oil has sent, or did you read the written statement?
Which written statement?
The response statement that China Oil gave in response to our statement of claim.
The decommissioning?
No, the statement that you gave, the statement on behalf of China Oil.
Yeah, the statement.
Yes,
that was not
yes, respondent submission, yes.
Okay.
Did you go through it?
Yes.
All right. Mr. Nanchang, in page 7 of your written statement, it says, however, if parent entity and subsidiaries have highly mixed corporate personality and the cost to distinguish is too high, which damages fair repayment of creditors, the court can decide to pierce the corporate veil of a limited company and order the parent company to assume the liabilities or debts of its subsidiary. So this is the statement, and a statement from the party that is a respondent, and you are representing the respondent today. Are you aware of this statement?
Yeah.
All right. And you have also stated that at the time of signing the agreement, although you were from China Oil, you posed as someone from Shanghai Oil and then signed the agreement.
Yes.
And in all the emails that we have received till now, except Exhibit 12 and 13, because we have not received them earlier, the communication was between you and BNOC.
Yeah.
All right. Honorable Tribunal, we would like to emphasize on the last 3 questions that we have asked and the responses that Mr. Chendu Nanchang has given to us, as well as his own admission that he had signed the agreement on behalf of Shanghai Oil, posing as the same employee for Shanghai Oil. We have no further queries to Mr. Nanchang. We would like this Honorable Tribunal to proceed with any questions that they have, or the claimants to proceed with their further examination of the second witness. Much obliged.
Yes. So can I ask my colleagues, this time can I ask Margub Kabir to start? Do you have any questions?
I just wanted to ask something to the witness.
Yes, sir.
I understand that you signed the agreement on behalf of Shanghai.
Yes, sir. I did. As a trustable person, I signed the contract on behalf of Shanghai.
Okay. And at that relevant point, did you have the authority to sign on behalf of Shanghai?
Yes, sir. China will give me instruction to sign the contract. So as a trustable person, I did that.
So the authority was given by China Oil to sign the contract?
Yes, sir.
Okay. So no further questions from me.
Thank you.
Thank you. Samir Sattar. Mr. Sattar, do you have any questions?
Sir, I have no further questions at the moment.
Thank you. I just have one question, which is the authority that you received from China Oil to sign the contract on behalf of Shanghai Oil. Was that given in writing?
Sorry, sir. Can you please repeat
the authority to sign the contract, the initial contract, was that given to you in writing by China Oil?
No, sir. That was not in a written form, but they orally informed me to sign it.
Okay.
And it's not any issue if I sign the contract on behalf of Shanghai. All the contractual terms were being perfectly performed by them. So signing the contract doesn't make any issue with that.
No, that's fine, because we have an issue to decide as to whether the proper party has been joined in the proceedings or not, because the contractual party and the party with the arbitration agreement is Shanghai Oil, as I understand it. And that was the question which was asked by my colleague, Mr. Sattar, right at the beginning, that why haven't Shanghai Oil been made a party to these proceedings? So we'll have to decide that. But I just wanted to understand the scenario, the actual scenario of you signing. So you got verbal instructions from China Oil to sign the contract. Were you present in Bangladesh at the time when the contract was signed?
Yes, sir.
And the other question is that, is there anything from Shanghai Oil giving you authority to sign the contract on its behalf?
Sir, as all the employees are provided by China Oil, so as China Oil instructed me, so I signed it. There was no other authority of Shanghai to appoint that.
That's very helpful. Thank you very much. I don't have any further questions. Do either counsel have any questions arising out of the questions from the tribunal?
No further questions from me, sir.
From the counsel for the parties, do you have any questions of this witness?
No further questions from the claimant, sir.
Okay. And from the respondent?
No, sir, there is no question.
Okay. So then we can proceed to the next witness, right?
Yes. Honorable Chairman, if you permit, may I chief examine our last witness, Fung Sung Wangru.
Here's the name again, please.
Fung Sung Wangru.
Okay. Yes, please call your witness.
Much obliged. Good morning, Fung Sung Wangru. Would you please state your name for the record, please?
I am Fung Sung Wangru.
And Mr. Wangru, what is your designation in China Oil Company?
I am the Managing Director of China Oil Company.
And would you tell the respected arbitration tribunal why are you here today?
Because Bangladesh National Oil Company demanded that China Oil Company, at its sole cost and expense, will decommission and remove the offshore platforms located in the field.
So, can you please state which kind of corporation was China Oil Company?
It's a state-owned public limited corporation.
And where was China Oil Company's headquarters?
In Shanghai.
Mr. Wangru, do you know why the Ministry of Resources and Exploitation of Bangladesh invited bids from International Oil Company?
For offering the oil companies the opportunity to bid for concession to explore, drill, and produce oil.
Who was the successful bidder?
China Oil Company.
How many projects are you running worldwide?
There are several projects, 10 to 12 at the moment.
How many projects are you running in Bangladesh?
A few. Obviously more than one.
When did you appoint project leader in Bangladesh?
I appointed Chengdu in 1990.
Is he the only person who is looking after all the projects in Bangladesh?
Yes, Mr. Chengdu is the only person.
Did you delegate him to sign the agreement of 1992?
Yes, I have delegated Chengdu, and China Oil provided all the employees and assets to Shanghai Oil.
Who signed the agreement?
Chengdu signed the agreement in 1992.
Did you instruct Mr. Chengdu to look after this particular project?
Yes, I have.
Did you instruct him to appoint someone from Bangladesh?
Yes, I have instructed him to appoint Mr. Mukhlis ur Rahman from Bangladesh.
What was Chengdu's role throughout the project?
He had a supervisory role. He was also the project leader of Bangladesh.
Was there any clause in the deed of agreement relating the breach of the clause?
No, there was no such agreement.
So who will be responsible for any breach of the clause?
Shanghai Oil.
Was there any conversation with Chengdu about the performance guarantee?
There was no conversation with anyone of Bangladesh National Oil Company about the decommissioning during the contract session.
What did you instruct to Chengdu about the performance guarantee?
That China Oil Company will not take any performance guarantee.
Was there any conversation with anyone of BIAC about the decommissioning during the contract session?
No, there was no such conversation.
What did Chengdu tell you about the email from BIAC?
Which email are you talking about?
The email dated 2nd January 2013.
Oh, Chengdu told me about that. They are requesting for decommissioning, which was not in their agreement before the contract started.
And what was the reply?
Reply from Chengdu replied that they cannot do it because it's a high cost thing and we needed a separate agreement for that.
Why didn't you agree with decommissioning?
Like I said, it was a $100 million cost project and we needed a separate agreement. We needed more people to sit together and agree with this.
What was your proposal to BIAC about the decommissioning?
Our proposal was that we need a separate agreement, and without that, we cannot consider about decommissioning.
And what was the reply from BIAC?
They did not provide any reply.
Did BIAC provide any kind of separate agreement?
No, none.
How many times the issue of decommissioning arose among you?
Only after the contract ended.
No further question. Thank you.
Thank you very much. Samir, do you have any questions?
No, sir, not at the moment. I will. I'm reserving my questions after hearing the closing submissions from both sides.
Okay, Mr. Kabir.
I have no further questions at this stage, sir.
Thank you very much. I also don't have any questions. Thank you.
Honorable Tribunal, can I start the cross-examinations of Mr. Wang Ru now?
Yes.
Mr. Wang Ru, am I audible to you?
Yes, you are.
Please state your full name for the record.
I am Fuksok Wang Ru.
And you are the managing director of the China Well Company. Am I right?
Yes, that is.
Mr. Wang Ru, when have you first come to know about this arbitration process, today's dispute?
After the contract ended, which was in January 2013.
Mr. Wang Ru, as you have known, there was a written submission submitted by the respondent. Have you gone through it?
Yes, I have.
To the submission, have your approval?
Yeah. Are you asking me?
Yes.
Yeah, go on.
Mr. Wang Ru, do you agree Section 6 of the Bangladesh Petroleum Act 1974 imposes an obligation to conduct petroleum operation in compliance with good welfare practice?
Yes.
Do you agree that the good welfare practice, along with other factors, include the protection of environment?
Yes, it does. But during the operation of the contract.
Under the Bangladesh Petroleum Act 1974, it is a duty of the person engaged to consider environment and ecological factor while conducting petroleum operation. Am I correct?
Yes.
From the respondent's statement, it is essential to return the water to its original conditions after the recycling of the wastewater. Am I correct?
It could be, but there has to be some agreement, separate agreement for that.
Mr. Wang Ru, let me put it down to you. You have suggested the ETP recycling process to prevent any kind of water pollution. So, Mr. Wang Ru, you agree that this offshore structure can cause environmental degradation?
Yes, it can if we are not careful enough.
Then this puts you under an obligation to ensure prevention of environmental degradation by removing the structure once the contract reaches end. Am I correct?
No, by no means. Not after the removal. I mean, why are we even talking about the removal? Whatever the environmental concerns are here are only about the operation of the contract, not after it.
Mr. Wang Ru, you have in your opening statement showed the picture of the decommission, and you have said that this might cause environmental pollutions if not decommissioned properly. And also you have agreed that the petroleum operation causes environmental degradation. And also you have suggested, I repeat, the statement submitted by the respondent, it has its suggestion that the water should be returned to its original conditions using the ETP process.
First off, when the opening submission was given, that was not in, I did not give it. It was my counsel. Secondly, yes, there can be problems. There can be environmental problems when decommissioning occur. But I also meant, if you listen to my counsel carefully, that they also mentioned that decommissioning should be regulated by some tight legal framework, because if not, then there can be problems. There can be accidents that can happen.
Mr. Wang Ru, the counsel represents your company, the China Oil Company. Thank you, Honorable Tribunal. I would like to, I would like this point to be noted that there is an obligation to environmental pollutions, and it needs to be decommissioned to prevent any further harm to the environment. Mr. Wang Ru, you have said that you have 7 projects you have 7 projects worldwide. Can you state to the tribunal what kind of projects are you talking about here?
I said 10 to 12 projects, all related to oil fields around the world. That is what we are doing as a company.
So you claim to be an expert organization of petroleum operations. Am I correct?
Yes, of course.
Then you must have idea about these decommissions beforehand.
Yes, any other company would. But like I will again say that there has to be a separate agreement, like any other good company would have. There can be United Kingdom's contracts where you would see Shell United Kingdom had a separate agreement.
Mr. Wang Ru, separate or not, there is an obligation on the international oil company to decommission.
What obligation are you talking about? Any specific obligation from any specific provision?
I'm talking about the decommission.
Yes, there can be obligations, but which one are you talking about?
There is an obligation on that. There needs to be decommission.
It depends on case to case. It depends on case to case.
But you have decommissioned before, haven't you?
Not before 1998. There's a difference. We had this contract. We were going to have this contract in 1990 or 1991 when IMO resolution clearly states that any contract before 1998 are not obliged to decommission.
Mr. Wang Ru, can you just answer me this question that under Schedule 1 of the Environment Conservation Rules 1997, exploration and extraction of mineral resources falls as a red category project. Am I correct?
Yes.
Do you agree that the project leading to today's dispute is an oil exploration, hence falling under the red category under the Environment Conservation Rules 1997? Am I correct?
Yes, you are.
Then tell me this, that the project fulfilled all the preconditions for renewal, including the portions of the outline of relocation and rehabilitation plan. Is that correct?
Yeah, it is.
Then do you admit you have responsibility of relocation and rehabilitation?
Yes, I do.
As per your statement, the legal meaning of relocate means move to a new place, and rehabilitation means the restoration of former rights. Am I correct?
Yes.
Decommission means similar thing. It means returning the ocean and seafood to its precondition. Am I correct?
There is a difference between same and similar. Decommissioning is not the same process.
Probably the not process, but it means not using the same process, but it means like returning the ocean to its previous condition. That is correct, right?
It is not. It is not correct. Decommissioning and returning the ocean to the previous state has nothing to do with relocation or rehabilitation.
Mr. Wang Ru, I'm just referring to the meaning of these two terms and saying that they mean to restoration of the former rights. And that is also given in your statement, Mr. Wangru.
Is that restoration of the sea or restoration of the equipments?
That's written in restoration of the former rights in your statement, Mr. Wangru. That is
Former
provided by
rights.
the respondent.
You need to understand what former rights are we talking about?
Have you specified that in your statement?
Oh, no, because it's not about decommissioning. I'm not talking about decommissioning. Decommissioning has nothing to do with former rights, do they?
Let me put this down to you, Mr. Wangru, that as per your statement that you are just providing now, also the respondent statement that has been submitted. These relocations commissions have been that the restoration of a lot of projects worldwide.
We are having a bit of difficulty hearing you. Can you please? I don't know. It looks like Samir is also having the same problem. Can you please go back a bit?
Sir.
Can you go back a bit? I think we seem to have lost both the counsel and the witness.
I am here, sir.
You're there? Okay, what about the witness?
I am the witness in this case.
Okay, you're the witness, but counsel?
I think she's not here.
Right, okay, let's pause a little bit and let's see let her come back.
Yes, sir.
Honorable Tribunal, the counsel has just lost her connection. She's coming back in a few seconds. Apologies for the inconvenience.
No problem. We'll wait for her. Yes, counsel. Counsel, I think you've got yourself muted.
Yes, no. I'm extremely sorry, Honorable Tribunal, for the inconvenience and also to the respondent team. I apologize.
Not a problem. Please proceed.
Thank you. As I was mentioning, Mr. Wangru, that you have mentioned you have several decommissions, you have several projects worldwide that is related to this well exploration projects, and also you have said that you have decommissioned earlier. So can you tell me, or can you tell the tribunal, what particular decommission technology have you started, have you adopted so far?
There are several technologies. There has to be advanced technologies, but it also depends on the fields that are being constructed. The field that was constructed in Bangladesh is constructed in a way that is not really, it is not suitable for decommissioning.
Have you conducted any kind of test or any kind of experiment regarding this?
Do I have to? No, because I did not talk about decommissioning in the beginning to begin with. So why do I have to ask or go around telling about decommissioning or look for something that decommission?
Mr. Wangru, let me put it down to you. Have just mentioned that the Bangladesh field is not suitable for decommissioning. You have must conducted any kind of experiment to came to the conclusion to such observations. But since you have mentioned that you have not conducted any, you cannot just assume anything, Mr. Wangru.
You also cannot assume anything when there is nothing written.
Mr. Wangru, this is your statement, Mr. Wangru, that the field of Bangladesh is not suitable for decommissioning. It's not something that I have come with. Mr. Wangru, my next question to you is, in your witness statement, you have mentioned that after a long conversation with the Bangladesh National Oil Company, you reached to this decision that Shanghai Well Bangladesh will be the signatory for the agreement of exploration, drilling, and production. Am I correct?
Yes.
Do you agree your submission is contradictory with the Bangladesh leader of the project? He submitted there was a last-minute notification. I repeat, last-minute notification about the involvement of the Shanghai Well Company.
Can't you have last-minute hours of a conversation whenever we need them? We did have hours of conversation about this in a day. Yeah, that is last minute, but we did it anyway.
Yes, but Mr. Wangru, this is contradictory to the statement provided by Mr. Nanchang. At this point, I don't have any further question to you. An honorable tribunal, from the statements of Mr. Wangru, we can say that there is an indeed an implied obligation of the China Well to do commissions, and they had also a strategy, as they have been rightfully referred in their statement also, that they have followed the Environment Conservation Rules 1997 and the Act 1995. An honorable tribunal, I would also like to mention that the chief commission in the chief examinations, Mr. Wangru was mentioning about something, Mr. Mokhes, which we are unaware of. We have not been pre-notified about any of that sort. Thank you, honorable tribunals. This is all from me. And with your permission, I would like to give the floor to Mr. Rahman to continue with the hearing procedure.
Before you give the floor to Mr. Rahman, perhaps I'll just ask my colleagues whether they have any questions in respect of the evidence given by Mr. Chengdu.
Much obliged.
Yes, Mr. Kabir this time?
No, sir, I don't have any question at this stage.
Mr. Sattar?
No further questions, sir.
Okay, I was just looking at the timetable to see how we are doing for time, because I'm on a different time zone. Can someone help me with Mr. Sattar? Can you help me with how we are doing? We're supposed to finish cross-examination.
Yes, sir. It's 1:20 in Bangladesh. It's 1:20 p.m. in Bangladesh. We were supposed to be closing this arbitration along with the closing submissions by 12:45. So we are running almost half an hour, 35 minutes behind schedule.
So we started about half an hour late, right? This morning?
Yes,
Yes,
I think, sir,
about 20 minutes
we're
late.
a little delayed, but I think we can.
It's all right. It's convenient for everyone to continue. Yeah. No one needs a break. Okay, fine. I'm comfortable. So please continue. Submissions now, right? So the witnesses have been dealt with. Is that correct? Counsel for the claimant?
Yes, sir.
And counsel for the respondent? All the witnesses have been dealt with, right?
Yes, sir.
Yes, sir.
Fine. So, okay. So we are now going to submissions from the claimant and then submissions from the respondent, right?
Yes, sir. That is correct.
Sir,
okay.
with your permission, sir, if before the beginning of the closing submission, I had two queries for the counsel for the claimant as well as for the respondent. Perhaps they can address that in their closing submission. If you allow me, sir, then I'd like to raise those questions before.
Yes, Mr. Sattar, that would be very helpful.
Counsel, for a quick, thank you, sir. Quick question for the counsel for the claimant. Before we have heard the witnesses, we have heard your opening. Thank you very much. But what I would like to hear from you in your closing submission is the circumstances surrounding the fact of the arbitration agreement, very specific to the arbitration agreement. And how does the respondent come into play, and how are you dragging a party who is not a signatory to the contract, underlying contract itself, to this arbitration? And what correspondence or what evidence have you seen between the parties in relation, not to the dispute? I'm not talking about the dispute. I'm talking about the particular arbitration agreement, which gives us the jurisdiction to hear your dispute. So if you can spend a couple of minutes clarifying your position, then we would be very grateful. And the same goes for the counsel for the respondent, that was any objection raised? I've noticed your statement of defense where you've admitted to the jurisdiction, but apart from the admission, was there any correspondence in relation to any particular objection before this arbitration started in relation to this arbitration proceeding to BIAC? So these are similar questions to both the councils, and perhaps this would give the tribunal some insight as to how it will decide going forward. So if you can address those very shortly, then I would be very grateful. Thank you.
May I proceed now, Mr.
Yes,
Arbitrator?
Please do.
The questions you have raised were supposed to be originally argued in my closing statement as well, but for now, I will summarily address the two issues you have raised. Firstly, how we are incorporating both Shanghai and China Oil Company is that we are addressing them as a single economic entity. And this single economic entity is identified by the parent company, China Oil Limited. And our argument is that if that corporate veil is lifted, it would be quite obvious and clear why we are arguing that the true respondent to case is in this case is China Oil Limited. Secondly, how the circumstances is going to evaluate it is, in this regard, our submission is that we have mentioned how the laws impose a liability and how the laws actually mandate the procedures to be followed, and which actually, in a sense, resonate that there was an understanding of decommissioning liability. If Mr. Arbitrator Sattar is satisfied with the answer, may I proceed with my closing statement?
Well, please proceed. I will see if he has any supplementary question.
Please do proceed.
Thank you, Mr. Chair and arbitrators. Thank you for the floor again. A lot has been heard already, but in this closing argument, I will summarize all the legal arguments and the factual happenings, as well as I'll try to provide the answer. Am I audible to this tribunal?
Yes, you are to me. Thank you.
Okay. Sorry for the interruption. Your screen froze. So in this closing argument, I will be summarizing all the arguments and also try to provide this tribunal with the answers they are looking for. Firstly, it is very unfortunate that the respondent has chosen to struck the heart of the confidence of this court by trying to mislead and misrepresent the facts. First of all, they have presented an exhibit of deed, which was quite unknown to us, where they have stated that there was a Republic of BNOC. They have mentioned the laws of BNOC, whereas BNOC is a mere company, not a country. And they have misrepresented the consent of our witness, Kausar Ahmed, in that particular deed. Secondly, although the court did not allow the exhibits number 12 and 13, they have implicitly been dragging those issues in here. In this regard, I would like to quote Mr. Justice Muzammil Hossain from the case Ishtarul Haq Chowdhury versus Amir Hossain, cited in 33 BLD, Appellate Division 323, that the court bases its decision on what the advocate is presenting to them. And it is a sacrosanct obligation on the lawyer to not mislead, misrepresent, or obfuscate the court in any manner. However, we have seen the respondent not honoring this code. This is very unfortunate. Now, if we go to the rebuttal section, they have mentioned about how they have exploited beyond the territory what we represented. But here, our submission is that there was fraudulence on our part because it was mere result of the dispute of Bangladesh versus Myanmar case that was published in 2012. Again, it does not affect our current dispute because they have already benefited USD 350 million from the contract. Now, moving on to our three arguments. First of all, why we are claiming that the true respondent is China Oil Company Limited. Firstly, our submission was that if corporate veil is lifted, it will be quite obvious. Now, why should we lift the corporate veil? Because when a new company is trying to evade its obligations through another company, subsidiary company, it would be quite obvious when the corporate veil is lifted. Hence, we submit the case of Guilford versus Horn, CH 935 of 1933, where the court, the Court of Appeals found that the new company was a mere cloak for the parent company to escape liability. The second question is, when can we lift the corporate veil? The answer to this question is has been answered by Justice Khairul Haq in the case of Patimas International Malaysia versus Review Panel. In that case, Justice did acknowledge the Salmon case, as the respondent has also did, but he quoted Justice Slade that while the characters of the persons of parent company and subsidiary company have been mixed, it is the duty of the court indeed to investigate that relationship. Furthermore, that particular case also referred DHN Food Products Limited versus Tower Hamlets 3 all ER 462, where the Court of Appeals found that if it can be proved that the subsidiary companies were indeed a single economic entity, it is good enough reason for the corporate veil to be lifted. Now, the last question is this case good enough reason for the corporate veil to be lifted? A very obvious question, Mr. Arbitrators. Firstly, I'd like to refer the case of Patimas International again, where Justice Khairul Haq referred to the quotation of Justice Atkinson, where the Justice Atkinson actually originated the concept of single economic entity. He stated that if the company is in effectual and constant control, it will be deemed as a single economic entity. Furthermore, we can refer to the Indian cases such as Novartis, Adarsh Pharma, such as State of UP versus Renu Sagar, New Horizon versus Union of India, where the court has held that if factual control can be proved, it will be deemed that the companies were actually single economic entity. If we go through our witness testimonies and if we read from case paragraph 2 to 4, it would be quite obvious how China Oil actually negotiated, China Oil actually was the true bidder, how their employees, Ms. Chengru, Nanchang, maintained a position in both the companies, and how they had no capital and employees. Such, it is quite obvious why these two companies should be rendered as a single economic entity, and we're identifying that single entity through the parent company. So I would like to submit that this court declares that the true respondent, this tribunal declares that the true respondent to this argument is the China Oil company indeed. Secondly, their denial to our relief was that they had no obligation to decommission. Now, they have constantly stated that there is no state that imposes an obligation under them. But however, we'd like to refer two cases, Baltimore and Ohio versus United States, where Justice Sanford observed that implied contract can be there if there is an understanding between of the obligation and there is a circumstances in support of that. Also, according to Chavez versus United States, 175 US 552, implied for there to be implied obligation, it is not necessary to be there to be mutual assent. As we can see from the Environmental Conservation Act 1995 and the rules there under, and the Good Oilfield Practices clause from the Petroleum Act 1974, how there was a passive obligation and how there was an understanding of the decommissioning liability. Also, as an international company, China Oil was well aware of the unclosed provisions under Article 60, Clause 3, under Article 202, that there was an obligation of decommissioning. Our second argument is that they are saying that they are not agreeing to the implied obligation. However, there is no provision in the deed itself where they have been indemnified of their decommissioning liability. There is no exclusion clause that actually says that China Oil Company has or the Shanghai Oil Company has no decommissioning liability. Lastly, they have referred to Lord Denning, and in this regard, I would like to refer to a Bangladesh case where Lord Denning has been quoted, M.A. Jalil versus Rupali Bank, 2005, 34 CLC, Appellate Division. If a passive stance amounts to endorsing infliction of oppression on an innocent party, the court cannot but establish an implied obligation. And inadvertently made oversight should not restrict the court in this regard. Hence, we can see if the obligation are evaded from the China Oil Company, or if they actually not held liable, they would be unjustly enriched with the 350 million profit they have reached, and it will be quite oppression and infliction of the burden to us. Thus, our submission is that this court, this tribunal, declares that China Oil has an obligation for decommissioning and plugging. And our last submission is why China Oil Company should bear 70% of the decommissioning cost. Hence, we draw the attention of this tribunal to Lex Petrolia. In Kuwait versus Amin Oil, it has been stated and recognized as an applicable principle. In British Petroleum versus Libya, Lex Petrolia came to establish itself as a customary law for oil industry. In Aramco versus Saudi Arabia, in the cases of Safer International Petroleum versus NIOC, the tribunals held Lex Petrolia with relation to equity principles and good faith principles. We can see that in the absence of provisions in the Libyan law, the British Petroleum versus Libya Tribunal held Lex Petrolia as a source of subsidiary obligation. Now, as well referring to Lex Petrolia, we can also cite the cases in Pakistan, in Malaysia, in India, how abandonment cost is actually beared 100% by the contractor. We have been referred to the incident, the example of Nigeria, and also the respondent has mentioned about UK. Very unfortunately, they are not aware that the operate of UK guideline strictly states that it is a fundamental obligation and understanding that decommissioning liability will be on the part of the contractor. However, since they have already disagreed that they will not bear the full liability cost, and we have come to an arbitration, and it is of our own goodwill that we have decided to divide this cost on an equity principle and on the basis of doctrine of proportionality. This doctrine of proportionality we have based on the how we have shared our production. That was 70:30 ratio. Again, why are we implying the doctrine of proportionality ratio? The doctrine of proportionality and the proportionality test has been regularly applied in international investment disputes, where the court, such as Saluka versus Czech Republic, Electrobel Hungary, Tekme Tribunal, all apply this proportionality test. However, we do agree that this proportionality test can be different on the subject matter of this case. And in our case, we are invoking this court to find it on the basis of how we have shared the production. Thus, our submission is that this court, this tribunal orders that China Oil is liable to pay 70% of the cost for decommission. In summation, we'd like to say that if this court, if this tribunal does not find China Oil liable for the decommission, it will be an unjust enrichment on their part, since they have already gained enough profit from this contract. Again, it will the ends of justice will not be met if we are to bear all the commissioning cost. And lastly, I would like to reiterate the remedies we are seeking. First, the declaration that respondent in this particular case as a single entity is indeed the China Oil Company Limited. Secondly, they do have an obligation which is implied in the contract of decommissioning and plugging the wells. And thirdly, they should bear the cost of decommissioning on the 70% ratio, whereas we have agreed to bear the 30% ratio. If this tribunal has no further question, I would like to raise my case here. Mr. Chair, arbitrator.
Sir, you will need to unmute. Sir, you will need to unmute yourself.
I have unmuted myself. Sorry, forgive me.
Was I audible throughout my session, sir?
Yes, you were audible completely, and I've taken a very good note of what you have said. I was going to ask my colleague, Mr. Kabir, whether he has any questions to ask you, and then I was going to turn to Mr. Samir Sattar. I personally have one question, and I will ask it right at the end. Mr. Kabir, please.
Yes, the question that I had as a follow-on question of Mr. Samir Sattar was that why did you not make Shanghai a party to this arbitration agreement, to this arbitration? I mean, I understand that you brought in China because you primarily had your cases that you primarily had negotiated with them, but why was Shanghai not made a party to them?
Thank you, sir. Sir, as we have referred to the concept of single economic entity, when we're implying the obligation on China Oil Company as a parent company itself, Shanghai Oil Company by default it has become a party to it.
But Shanghai is a separate legal entity. Isn't that correct?
So it was our argument that they are a single economic entity. Although we do agree that there can be separate entities, but in this particular instance, as we have seen, and it will be quite obvious if the corporate veil is lifted, that they are indeed single economic entity.
Okay. And another question was, at the time of signing of the agreement, I understand that one of the officials of China Oil signed the agreement.
Yes, sir.
Correct?
Yes, sir.
So did you at that stage seek any authority from that individual that they're signing it on behalf of Shanghai?
So they have always mentioned that it was their internal necessity and this will not affect the contractual obligation. And we maintain a good faith and trusted them. We did not see this incident taking place.
And lastly, about the decommissioning, your case is that it's an implied provision, right?
Yes.
So, but don't you think that the cost associated with decommissioning is so substantial that it should have been part of the contract? Was that in any way considered throughout the 20 years? Why whether decommissioning will be done by Shanghai or not?
So we did not find it necessary since under the ECC license, it was already a fact that they have undertaken the decommissioning liability. And the part of cost, it is since both the parties are in exploration industry, it was not something unknown to either of the parties.
And have you always contacted China Oil regarding the decommissioning, or have you also communicated with Shanghai, as primarily they're the party to the agreement?
Sir, according to international practice, the decommissioning issue appears when the exploration has reached to the point when decommissioning will be necessary. And we have at that time contacted them. We did not do it before because we had always had this belief that there was an implied decommissioning liability. So it was not necessary for us to communicate in this regard.
Okay. I have no further questions, sir.
Thank you, sir.
Mr. Sattar, any questions of council?
No, sir, no further questions. Thank you.
Honorable Chairman and the other
Yes.
arbitrate tribunal. May I proceed with my closing statement on
Should
behalf
I
of the
take-
respondent?
Before you start, I have one question. I've got one question of counsel for the claimant. You referred in your submissions to the 1974 Petroleum Act, and you said there is a reference there to good oil field practices. Is that correct?
Yes, Mr. Chair.
And what is the exact provision? Do you have the provision
in section 6, subsection 1 of the Petroleum Act 1974, it is stated that every person involved in oil exploration shall abide by the good oil field practices.
Good oil field practices. And
Yes.
are they defined anywhere, good oil field practices, and how far they relate? Because one of the issues that has been raised in this arbitration is that the good oil field practices relate to when you're exploring and extracting. After you're finished, it doesn't apply. So is there anywhere in the learning that you have researched, is there anywhere that you can point to show that good oil field practices include decommissioning and plugging of oil fields?
So firstly, the definition of the oil field practice is not a very contested one. Also, in our statement, we have submitted the Dubai definition where we have mentioned that how good oil field practice mandates the rehabilitation and why environmental aspects should be cared about. And environmental aspects and decommissioning is highly intertwined, because if decommissioning is not done, oil spill will indeed damage the environment. Also, we'd like to refer to the law of Brazil under Article 44. It mentions exact provision without defining the good oil field practice, but in that country also the contractor is liable for the decommissioning fully. The Brazil Petroleum Law 1997, Article 44.
Okay, thank you very much. We can now turn to counsel for the.
Just a follow-on. Can I just have a follow-on question?
Yes, certainly.
Isn't it correct that now, what the government has done, or is that they've included decommissioning in the agreement itself as a separate part? Is that correct?
It was never a separate agreement, as our witness have also mentioned before. From the 2008 model PS agreement, it is a part of the PS agreement now, and we clearly mentioned the DS agreement decommissioning rules.
It's specifically mentioned in the agreement now, right?
Under the PS agreement.
The requirement. Okay.
And the liability is on the liability is on the contractor fully.
Okay. So has it been anywhere in the past that when it comes to prior to this 2008 model agreement, in the past, did you have a separate agreement for decommissioning with the contractor?
No, sir, because before 2008, it was not necessary because under international practice, this kind of clause were not included in PS agreements. However, since all the countries were amending their laws, so we decided to rectify our PS model and included it in 2008 model.
Okay, no further questions, sir.
Much obliged.
Okay. Counsel for the respondent, can we have your submissions, final submissions, please?
Much obliged, sir. Honorable Chairman and the other arbitrators of the tribunal, I am Istiaq bin Farouk, representing my client China Oil Company, a state-owned corporation of China. Honorable Chair and the Arbitration Tribunal, may I proceed with my submission, please?
Yes, please, go ahead.
Much obliged, sir. I would like to start by answering the question raised by the respected arbitrator, Mr. Samir Sattar, regarding whether we gave any objection as to why China Oil is the respondent of today's arbitration proceeding. Yes, sir, we have given several objections regarding why the claimants claim that China Oil is the respondent, as the China Oil Company and the Shanghai Oil Company were standing on the principle of separate legal entity. And China Oil did not even the party of the contract with BIAC. Honorable arbitrators, the claimant stated that the respondent of this dispute is China Oil Company, which we clearly deny because we have informed BIAC at the later stage that it is required to use a new subsidiary company, which is Shanghai Oil Limited, and Shanghai Oil was registered and incorporated in Bangladesh under RJSC to be the only party in both PS agreement and operating agreement. Even both the PS agreement and operating agreement was signed by the Shanghai Oil Company, which can be found in the last page of the deed of agreement we provided as Exhibit 2. Honorable arbitrators, may I refer you to Article 1.1 of the PS agreement, which also referred Shanghai Oil as the party of the contract. And the second clause of the Article 1 stated expressly that BIAC and the Shanghai Oil will together be responsible for conducting this petroleum operation, and there was no reference of China Oil Company. Honorable arbitrators, this is my humble submission that the claimants may fail the case because of defect of parties, and the respondent they have made would not be the respondent at all. In the present case, we are considering China Oil as the parent company and Shanghai Oil is the subsidiary of China Oil Company. With subsidiaries, liability is limited for the parent company. This is due to the autonomy because they can carry out activities by themselves which are different from the activities carried out by the parent company. For this reason, subsidiary is liable for its own debts, and therefore the main company is not affected. Moreover, as the claimants are claiming to lift the corporate veil, we would like to state that the corporate veil, I apologize, the corporate veil cannot be lifted in the case, as Shanghai Oil is a regular subsidiary of China Oil, which enlisted in different countries, and both the companies stand on the ground of separate legal entity and run independently. According to Guilford Motor versus Horn and Jones versus Liefman, if the corporate structure of subsidiary companies is used to conceal the true facts or to perpetuate fraud or create any manipulative circumstances by the sake of parent company, then the corporate veil may be lifted to decide the liability. As Shanghai Oil Company dealt the contract independently and very professionally without doing any fraud or corporate crime by using the shield of parent's company, even Shanghai Oil completed the contract within the stipulated time and did not breach any single obligation under the deed of agreement. So it is quite clear that there is no place in the corporate veil to preach in the present case. Rather, the China and Shanghai Oil will be considered as separate legal entity and each will bear its own responsibility. Honorable Chairman, arbitrators, China Oil Company
has no obligation under national law of Bangladesh and international oil field practices to decommissioning, as there was no express provision regarding the decommissioning in the PS agreement. In the absence of an express term to decommission, the respondent will never have the duty to do it. It is possible that an implied term could be present to decommission, as Lord Denning stated in Shell UK Limited versus Lowestoft Garages, that there has to have a substantive law in order to incorporate the implied term without either party's intention. Moreover, this approach of incorporating an implied term had also been taken in Liverpool City Council versus Irwin. The House of Lords held that any obligation which was imposed by the law could be treated as an implied term, and it doesn't matter whether the parties intended or not regarding the term. So it is fair to say that decommissioning would not be an obligation even by the way of implied term, because there is no law in Bangladesh regarding decommissioning which can be imposed on any parties. And it is quite surprising why the claimants are trying to impose the huge obligation of 100 million USD to China Oil Company impliedly for the sake of business relationship. Now I will discuss whether the China Oil Company had any obligation. Moreover, as the PS agreement is silent on the decommissioning and the definition of petroleum operation and agreed work plan have never included decommissioning. Honorable arbitrators, may I refer you to the 5th clause of the Article 1 of the PS agreement, where it is clearly stated that facilities and equipment provided by the Shanghai Well shall become the property of BNOC once they enter the country, which is Bangladesh. So it can be said that BNOC is the owner of the installations, and such installations are form of environmental hazards with serious environmental impacts, and therefore the applicability of the polluter pays principle would ideally make the owner of the installation bear the decommissioning liability. The OSPAR convention also has the same convention regarding the liability of decommissioning. However, honorable arbitrators, I would like to refer you to the 5th part of the statement of claim. We strongly agree with the first line of the last paragraph of this part of claimant's statement that the obligation of Bangladesh are significant point, because since it was Bangladesh that placed the installation, it has a duty to remove it. And this is what the respondent is trying to establish throughout the today's proceedings. However, the contract of the oil concession between BNOC and Shanghai Oil was specified in the continental shelf of Bangladesh, as it was represented by BNOC. But the concession located beyond the continental shelf and exclusive zone of Bangladesh. The international regulatory framework of the decommissioning process is especially based on 1958 Geneva Convention on the Continental Shelf, 1982 UNCLOS, IMO Convention, OSPAR Convention, and each of them had given their guidelines regarding decommissioning of installation either in the continental shelf or in the exclusive economic zone. But the drilling oil concession in the present case by Shanghai Oil was located beyond the continental shelf and the exclusive zone of Bangladesh, but it was represented by BNOC to initially to Shanghai Oil that it is on the continental shelf of Bangladesh. So any responsibility beyond the continental shelf or the exclusive zone of Bangladesh will not be imposed upon any liability upon either China Oil Company or Shanghai Oil Company. In today's proceedings, honorable arbitrators, we have proved that firstly, the China Oil Company doesn't have any responsibility regarding decommissioning, as to it is not the party of the contract. Even neither any substantive law of Bangladesh impose any obligation upon China Oil Company, nor any international treaties or convention imposes such obligation for assistance of decommissioning process, which is costly as it is 10-stage huge process. And the claimant couldn't present any proper evidence in today's proceedings why they are referring China Oil as the respondent when the China Oil even is not the party of the contract with BNOC. And the claimant's witness, Ms. Akhtar, admitted in today's proceeding that China Oil Company did not give any performance guarantee of Shanghai Oil to BNOC. Nevertheless, they went to the contract with Shanghai Oil independently. And Mr. Kausar Ahmed, Director of Legal Affairs of BNOC, and the other witness of the claimants clearly admitted today that Shanghai Oil was the signatory party and there was nothing in the contract between BNOC and Shanghai Oil about China Oil Company's liability. Secondly, we have proof by examining our witness, the project leader and the MD of China Oil Company, that there were no condition of decommissioning either expressly or impliedly in the deed of agreement to decommission. And thirdly, BNOC had mailed to request for decommission the project leader after the expiration of the contract with Shanghai in 2013, where the contract was concluded in 2012, and the project leader denied to conduct the decommission through mail, as we provide as exhibit number 6. So it will be quite unfair to impose such burden of $100 million on any contractor like Shanghai Oil Company, to the Shanghai Oil Company as the party of the contract, and there is no liability for China Oil Company because China Oil Company is not the respondent for this arbitration proceedings. It is not fair to consider China Oil Company as the respondent. So we are requesting the arbitral tribunal to give the award in favor of us. Thank you, sir. If the Honorable Chair and arbitrator do not have any further queries, I would like to conclude.
Thank you very much, Mr. Farooq, for your submissions. I will ask my colleagues whether they have any questions to ask you. I have one or two questions, which I will ask at the end.
Sure, sir.
Can I start with Mr. Kabir on this occasion? Please, do you have any questions to ask?
Yes, so just one question is that regarding the expiry of the contract, is it your case that that the contract tenure was expired prior to the seeking of the decommissioning?
Sorry, sir, I didn't get you.
Is it your case that the contract tenure, you have mentioned that the contract tenure has expired prior to the seeking of the decommissioning? Is that your case, that it has expired?
No, sir, it is not our case, but as we have had a good relationship with Shanghai Oil, so we are telling this because we are trying to keep Shanghai Oil out of this decommissioning burden, because we have a good relationship with Shanghai Oil, and we do not consider us, China Oil Company, as the respondent of today's arbitration proceeding. So it is not our case, and it is not the matter to deal as to the expiration of the contract.
Okay, and another question which I have was, in your submission to the environmental department, did you submit any decommissioning plan while you're receiving the environmental clearance certificate? It is the case of the claimant that you did submit, you had to submit a decommissioning plan. Is that the correct?
We haven't submitted any decommissioning plan, and there was nothing in the contract to submit any decommissioning plan by China Oil Company. So we didn't submit any decommissioning plan.
Not even to the environmental department while you were renewing your environmental clearance certificate?
Currently, we do not have the documents, but yes, sir, when we are when we are doing the renewal of our environmental clearance certificate, which is ECC, we have had few plans, but we don't consider this as the part of the contract, and we are not the party of this particular contract.
Okay, so I have no further questions.
Thank you very much. Mr. Samir Sattar.
Sir, I have just one question. Counsel for the respondent, can you take me to your statement of defense, please?
Sorry, sir, there is an internet issue, sir.
Can you can you please take me to your statement of defense?
Statement of defense. Yes, sir.
Can you,
through the screen sharing?
No, just is the statement of defense before you?
I think your written statement, I think Mr. Samir Sattar is probably asking.
Yes, sir.
For that.
Should I show it by screen sharing?
No. Okay. Is it before you? Can you read out the first issue? Does the arbitral tribunal have jurisdiction to hear this dispute, and your statements that you have made in your statement of defense? It's on page.
Which particular part you are asking me to read?
It's on page 2. Can you read page 2 of your statement of defense, please? The ones that have been sent to the institution, which has been forwarded to us.
Determination of substantive and procedural laws applicable during the arbitration proceeding?
No. I have one statement of defense on behalf of the respondent, which says 1. Does the arbitration tribunal have the jurisdiction to hear this dispute?
Yes, sir. Yes, sir. Yes, sir.
Can you please read the paragraph just under the heading?
Does the arbitration tribunal have the jurisdiction to hear the dispute? It is admitted that the arbitration tribunal has jurisdiction to settle the dispute because it has been expressly stated in the PS agreement as well as in the operating agreement that any dispute under these agreements will be resolved under the rules of arbitration of the Bangladesh International Arbitration Center.
Okay, I'll just stop you there. Do you see the contradiction in your submissions and the statements that you have made? You've just told us that you've just informed the tribunal that you have objected to the jurisdiction of the tribunal, but from what I see in your statement of defense, that you have actually admitted to the jurisdiction of the arbitration tribunal. So I just wanted you to clarify your position. Which one do you stand by?
So on that particular part, we are saying about the Shanghai oil companies that the dispute regarding Shanghai oil and BIAC arbitration tribunal have the jurisdiction to have the dispute, but there is no jurisdiction regarding China oil company as we are not the party of the contract, sir. We are saying about we are intending about saying to Shanghai oil company.
Okay. I see what you mean. What you're asking the tribunal is to infer certain things which are not clearly stated in your statement of defense. Perhaps we'll have to take that into consideration. But I see that your main submission is that you are disputing the arbitration tribunal's jurisdiction on the ground that Shanghai Oil is the appropriate party and not China Oil. Is that correct?
Yes, sir. It is. It is correct, sir.
All right. No further questions, sir. Back to the honorable.
Much obliged, sir.
Yeah, thank you very much. Mr. Sattar, we will discuss this issue when we deliberate amongst us. So we will look at the submission which has been made by the respondent in the context not only of jurisdiction, but also on the question of whether they are the proper party to be joined. Anyway, deal with that. Thank you very much for your questions. I've just got a couple of questions relating to your submissions. Do you make any submissions on quantum? Because what is being asserted? Assume for the moment, if the tribunal were to find that you are liable, in which case have you got any submissions on quantum? Because what the claimant has said is the quantum is $100 million for decommissioning and plugging. And they have said that it should be dealt with proportionately and that you should bear 70% of it, meaning $70 million, and $30 million should be the responsibility of the Bangladeshi party. Do you have any submissions on that? Because I did not hear any submissions on the issue of quantum.
Yes, sir, we do have about that. We have submission about that, sir. As we are, first of all, sir, according to the international frameworks, as the governing law of today's proceedings is Bangladeshi substantive law, but Sir, we are as the governing law doesn't have any particular specific law regarding the decommissioning process, so we have followed the international regulatory framework of decommissioning, where sir, which is specially based on the Geneva Convention, so on the continental shelf, UNCLOS, IMO Convention, OSPAR Convention. Each of them have, sir, given the liability and the sir, IMO Convention and OSPAR Convention, both the convention had given the liability of decommission to the coastal state or the owner of the installation. Here we have submitted that the owner of the installation, according to the agreement, is BNOC, which is the Bangladesh National Oil Company. So it is their duty to decommission the installation. And IMO guidelines 1989 IMO guidelines and standard for offshore removal installation, we got there that it is the duty of coastal state, which is here the Bangladesh company, and BNOC is the state-owned corporation of Bangladesh. So BNOC is the owner of the installation, so they have the liability to remove the installation on the basis of polluter pays the principle.
Yes, thank you very much. But that was the question on liability. You know, I was asking about the amount, the quantum. The quantum, you know, what the claimant are saying is that please find for us, and can you please find for us on the basis that the cost of decommissioning would be and plugging would be $100 million, which is a reasonable amount because, you know, they're citing examples. They've given 2 examples where the cost was over $200 million. And they also said that the amount should be shared between the 2 parties, between the Bangladeshi party and the Chinese party on a 70-30 basis, because that was the rate ratio on which the profits were shared. So I'm asking whether you, on behalf of the respondents, have any submissions in respect of the amount and the division to be made.
Sir, we do admit with this jurisdiction that we at best can take the 30% and the BNOC will bear the 70% cost of the decommissioning.
So I think the figure was 70% to the Chinese company and 30% to you.
No, sir, we will not agree with that. And we want a separate agreement for this particular project.
That I understand. On the issue of liability, I understand your submissions on the issue of liability. You're saying this is not our liability; it should be borne by the Bangladeshi company, okay? Or
yes,
as the owner, or as the owner of the continental shelf, it should be the Republic of Bangladesh. So that I understand. But my question is really in relation to the amount. If we find that you are liable, what amount do you say we should award? Do you understand? So that is the base. Whether 100 million, which they're claiming to be the cost, whether it's a reasonable amount, and secondly, whether the proportion 70-30 split between the Chinese company and the Bangladeshi company, whether that is the right proportion. So that I'm asking whether you have any submissions on that.
No, sir. It is not reasonable to and not proportionate to split the amount 70 and 30, which is meant that 70% will bear the Chinese company and the 30% will bear the Bangladeshi company. It is not proportionate and reasonable at all. From it
okay.
Yes, sir.
Thank you very much.
Much obliged, sir.
One other point I wanted to ask you is on the question of liability. Do you have any examples of any situation where in the old contracts, because we know that the contractual regime has now changed, and the contractual regime has now changed, and now in all the new contracts, what is happening is that decommissioning is being added. But in the old days, what was the position practically? Were there any countries who were faced with the liability and the liability was established in any arbitration award or in any decision of any court? Are you aware of any of that?
Regarding decommissioning, sir?
Yes, precedent. Is there any? My question is there any precedent that is there any precedent which establishes that the liability for decommissioning and plugging falls on the contractor who has the PSA and the operating agreement, and where there was no express provision? Is there any precedent for that?
Yes, sir. We can see the Azerbaijan PS agreement, which was I couldn't remember the exact date of the agreement, but there was an agreement of Azerbaijan PS agreement where, sir, the case was quite similar as our case, our present case.
And what was the result?
Well, sir, result was the state, coastal state was borne all the cost, and all the process was monitored of decommissioning by the coastal state, on the country of which countries continental shelf was used. This was the coastal state was liable for decommissioning.
So that was decided on the basis of the law of the seas, right?
Law of the seas. Yes.
Okay, thank you very much. I have no further questions. So I think we have now come to the conclusion, haven't we, of the case. Unless my colleagues have anything to say or ask any of the council, I would basically declare that the tribunal hearing has now concluded. Are you happy with that, Mr. Kabir?
Yes, sir. I think.
And Mr. Sattar?
Yes, sir. No further questions.
Thank you very much. I was just going to now ask that the matter be, because according to the program, I see that I should hand over to our host, which is the chairman of the, sorry, not the chairman, he is the CEO of the Bangladesh International Arbitration Center, to Mr. Mohammad Ali Rumi, and for him to say a few words before he invites us to give feedback and then our decision. And also, I think there are a couple of people who are waiting to join us. One of them is a junior of mine who's familiar to both Mr. Kabir and to Mr. Sattar. His name is Mr. Mohammad Saifullah. He just sent me a message asking me what I'm doing. So when I told him I'm here chairing this arbitration, he says, can I join in? So if someone is hearing me from BIAC, can you please let him in so that he can at least see what we're doing? Thank you. Over to Mr. Mohammad Ali Rumi now.
Thank you. Thank you. Thank you, Mr. Chairman, and thank you for being here. I'm totally delighted. I've been listening to two parties to the dispute, and it was quite riveting. I thought I'd just come and go, but then I listened to all of it. So it just shows how much importance our young legal intellects have given to this case. Thank you very much for being here. And I'm also addressing our distinguished audience. Let me at the outset mention that our media partner is the only Bengali business daily, Bonik Barta. Actually, it has encouraged us. This whole thing has encouraged us. And BIAC now intends to host this competition as an yearly event. This is a part of our, what we call our outreach or advocacy. We'd like to actually reach out to the future arbitrators, the future legal minds of the country, to go for ADR in future and not go directly to the courts. And we all know how busy the courts are, and it isn't easy to get a decision. And as you saw over here, that we are getting a decision. Now, this may be because it's not a real story. It's something which has been constructed, but the real story can be like this or close to this. And that's something for you all to understand. We are now trying to move the University Grants Commission to actually add arbitration mediation as a part of the curriculum of all the universities and educational institutions which teach law. I think that would be an important addition, because according to what we know, that many of them don't. I'd also encourage all the students to become members of BIAC so that they can be in touch and know what's going on in the world of ADR, because it will be useful for you. And I'd also encourage you to join our training, particularly the accreditation training program, because you can enlist initially, at least, as a mediator, list of mediators. And after you do the accreditation for arbitration, you can also enter the list of mediators. We do that, of course. There is a small fee attached, but it isn't much. I'd also thank all the contestants for being here, and a big congratulations in advance to whoever wins, and commiserations to the other party who cannot win. But don't worry. There is another competition coming up in a few months' time, next year, and you can redeem yourself over there and become the champion. Let me also inform you that because it's a virtual thing, we couldn't hand out the trophies, but we are planning to hold the actual handing out of trophies ceremony, and certainly invite our chairman, who is right now in Singapore, to fly over and be there as an invitee, and of course also our arbitrator, Samir Sattar, Mr. Samir Sattar, and Margoob Kabir. I must thank them for being here today. I know they're very, very busy people, so they have given us a lot of time. So thank you very much. And I'd like to also share a happy story about one of our arbitrators, Mr. Samir Sattar, who has just been made it to the under 40 list in Asia by Thomson Reuters legal publication. Congratulations, Barrister Sattar.
Thank you.
And finally, I must thank all the audience for being here and encouraging our future arbitrators, and finally the team at BIAC, who have worked very hard to make this happen. With these few words, and once again thanking our chairman for joining us from Singapore, and encouraging everybody. I'm sure all these young people have learned a lot. They have also learned from 2 other arbitrators, but you have a lot of experience as an international arbitrator too. And anybody who is planning a career in law or arbitration, I'm sure they'll learn from your deliberation, which you will give, your feedback, which you'll give later. So thank you again. And now we'll proceed with who is the winner. We'll ask them to assess and give the feedback and declare the winner. So back to you, Chairman.
Okay, thank you very much, Rumi. Rumi is a very, forgive me, go on, Rumi.
You can go off for about five minutes and decide among yourselves. And in the meantime, we can put something on for others to concentrate in.
I was thinking that it would probably be better, because this is a mock hearing, that we do the deliberations in public. Okay, yeah. So everyone hears what we are deciding and how we are deciding. So if you can then understand the judicial mindset, it will become easier for you to address and become better advocates. Or also, if you want to be a witness, then if you're giving evidence, then at least you know how to keep yourself focused. So that's precisely what I want to do, and I discussed this with my colleagues. So I would propose that we do our deliberations in public. I know we have gone over the time limits that have been set, but if you don't mind, we'll take about 10 minutes or so, I think, to deliberate. And I think everyone will find it useful that we do this process publicly. Okay, you have no objections to that, right, Rumi?
Not at all. Please do.
Okay, good. I just wanted to say that, first of all, thank you to BIAC and to Rumi. Rumi and I have been school friends. We've known each other for a very, very, very long time. And so he has supported me in my practice. And also, I have supported him in his endeavors, when he was a deputy governor of the Bangladesh Bank. I had time to interact with him in a big way, assist him with many things with central bank's affairs. Of course, when he's been with BIAC, he's been very active in ensuring that BIAC provides a service to our country in resolving disputes, and obviously in every which way that I could, whenever he's asked, I've tried to be with him and support him and support BIAC. I'd also like to thank my co-arbitrators, Samir and Margoob. I'd never found out who's senior. Is Margoob senior to Samir or Samir senior to Margoob? Who's more senior?
Samir is senior to me.
Samir is okay. And I've known Samir from the time when he was at university, of course. So, Samir, I'm delighted that you are both here with me. At the moment, Margoob and I are doing an arbitration, and I gave him a pretty hard time drafting something, and he's still working on it. Samir and I have not worked for a little while, but we have, known each other for a very long time. And one of the things that I did say, for some reason, personal reason, he had to go to England for a couple of years, and he said, "What am I going to do there?" So I said to him, "Go and learn arbitration." So that's what he did, and I told him that go and get a first class, and he did. Okay, so that was amazing that he followed my advice, and he did it very well. And I'm very, very happy that today that he's joined the under 40 league. And Thomson Reuters have recognized his abilities. I'm really, really very happy about him, and I wish him all the success. And of course, I do wish Margoob also a lot of success, because he also has a very good future in arbitration and as an arbitrator. He used to work for Sherman and Sterling in Paris. So, everyone's got a lot of international experience here. So as far as your tribunal is concerned, it's an experienced tribunal. I also like to thank the participants today for their submissions, and the students of the Dhaka University and BIA Academy who have reached the finals, and also any students who have in fact been watching us. And certainly, as far as the participants and audience are concerned, I want to thank them for their support and for their interest in arbitration. Now, as far as the deliberations are concerned, I think if everyone else switches off their microphones and Margoob and Samir unmutes themselves, I think what we have here are three general issues that we have to decide. One, as to whether the China Oil Corporation is a proper party. And secondly, issue of liability, whether the decommissioning and plugging is a liability of the respondent, or whether it falls upon Bangladesh or as the owner of the coastal shelf, or whether it falls upon the owner of the property, Bangladesh National Oil Company. So that, and finally the issue of quantum, the amount of compensation to be paid. So on proper party, your thoughts, Samir, you being the senior, can you lead please? And tell us what your thoughts are.
Yes, sir. Yes, sir. Thank you. Initially, I was hoping that the respondents would have raised an objection to the tribunal's jurisdiction and the proper party, and they would have spent a substantial amount of time to do this. And I've learned this from you, sir, obviously, that during the time that I was working with you, you may remember on several arbitrations, the first thing that you taught me was to find out about the jurisdiction and actually study into it, because arbitration is different. It's the creation of an agreement. So if there's no agreement, unlike national courts, we know that arbitration tribunals do not have their own enforcement mechanism, right? And we will need to resort to local courts for enforcement. So if a tribunal like us, we render an award against a party which is not subject to the underlying arbitration agreements, problems may arise at the time of enforcement. Now, we all know about the Article 5 of the New York Convention, which provides 5 procedural defects, and one of which, important one, is the lack of a valid arbitration agreement. Arguably, an award rendered against a non-signatory to a contract can be challenged on the basis of any of those grounds that they don't have a valid arbitration agreement. and especially if there was no explicit correspondence in relation to this particular issue. And I'm not talking about the dispute, I'm talking about the arbitration agreement itself, which is separate to the underlying contract, which we all know. And also there has been a recent decision by the single bench of the Delhi High Court in the case of Sudhir Gopi versus Indira Gandhi National Open University, where it was held that the decision of the arbitration tribunal to pierce the corporate veil was flawed and falls foul of the fundamental policy of Indian law that recognizes that the company is an independent juristic person. Unless the shareholder, and this is what I was trying to get out of the counsel for the respondent, that unless the shareholder, which is China Oil, has expressly or impliedly agreed to be bound by the arbitration agreement, there is going to be an issue there. And arbitration has no jurisdiction over such shareholder. And this is very important, I think, sir, and obviously this is all subject to your views. And we're very eagerly looking forward to what your thoughts are on this whole argument itself.
Okay. Anything else on a proper party from Samir? Otherwise, I'll move to Kabir. Margoob.
No, that's fine. Those were my observations.
All right, Margoob.
Thank you, sir. Actually, basically, Samir has covered more or less what I wanted to say. Plus, I just wanted to add a couple of things. Was, you know, during the questioning, which the tribunal has questioned them as to authority, you know, when, you know, in which authority they executed the agreement. So there was something there where they said that China Oil basically authorized the individual to execute the agreement. So that's something which I think to an extent goes to, you know, the relation between China Oil and Shanghai and this agreement. I think that goes a long way. Plus the fact that, you know, contrary to that, another fact that, you know, the particular that they did not provide the performance guarantee at the last stage, and, you know, they say that they will not provide it. I think they have in a way protected themselves from liability to an extent right from there. So that's something I think which we need to consider as well while, you know, deciding the actual merit. And so far, so that's about it for now about the proper party.
Okay, thank you very much. My thoughts are like this, that look, we start from the negotiation of the contract. Who was the bidder? The bidding was done, and the bidder was China National Oil Company, okay? So that is one. And then the next question is who are the contracting parties? So obviously, you know, the contracting parties are Shanghai Oil and Bangladesh National Oil Corporation. So normally you would expect the contractual party to be the party, because you see the arbitration agreement is between Bangladesh National Oil Corporation and Shanghai Oil Corporation. So the jurisdiction point is that, you know, because it's consensual, those are the parties who have agreed to become, who have agreed to resolve the disputes by arbitration. So that's where the issue of jurisdiction arises, the points that both you and Samir have made. But then normally in a case like that, like this, you would expect the respondent to challenge jurisdiction, to raise jurisdiction as an issue. And obviously, as a tribunal, it is our job as well to ensure that we give a valid arbitration award. And if it's an issue of jurisdiction, which seems to apply in our case, then we have to then decide the issue of jurisdiction. So we are deciding effectively not just who is a proper party to this arbitration agreement, but whether we have jurisdiction to deal with this arbitration. So that is the more fundamental problem, issue that we have to decide. In deciding that, we have to take into account what the parties have put in. Now, Samir, you actually read out something. You have the benefit of this, you see, of having the document in front of you. I have the document on my handphone, so I'm having a bit of difficulty, you know, reading through it. But you were referring to this clause in the respondent's submission, right? Under jurisdiction.
Yes.
Yep, paragraph 2.
Can you please page 2 of this?
Yeah, can you please read that out? Can you please read that out so that both Margoob and I can hear that, and let's see what we can get out of that, whether there is an admission by China Oil Corporation or not. Okay.
Yes. So the page 2 of their statement of defense reads, does the arbitration tribunal have the jurisdiction to hear this dispute? It is admitted that and it goes on to state that it is admitted that the arbitration tribunal has jurisdiction to settle this dispute because it has been expressly stated in the PS agreement as well as in the operating agreement that any dispute under these agreements will be resolved under the rules of arbitration of the Bangladesh International Arbitration Center. It is further admitted that under the BIAC arbitration rules 2019, Rule 21, subsection 1, the arbitration tribunal can rule on its own jurisdiction, including any objection with respect to the existence or validity of the arbitration agreement. And the provision also allows an arbitration clause in an agreement to operate as an independent arbitration agreement. And then it goes on to state one paragraph on the Bangladesh Energy Regulatory Commission, BIRC 2003, which they ultimately say that this is not relevant in this dispute. So there is a clear admission by the respondent to the jurisdiction, to the arbitration jurisdiction, arbitration tribunal jurisdiction over this matter.
And the parties in the arbitration are Bangladesh, the Bangladeshi company, and the Chinese
the
company,
Bangladeshi
right?
government company.
Yeah, Chinese company, the holding company, not the subsidiary, Bangladeshi subsidiary. That's right.
Yeah, not the Bangladeshi subsidiary. It's the arbitration is between the Bangladeshi government entity and the Chinese company as the respondent, whereas in the agreements, underlying contracts, the parties are the Bangladeshi government company entity, state entity, and the local company, Shanghai.
Yeah.
So clearly there is an issue there.
Yeah.
Sir, if I may also add just one thing, even in the deliberations, like in the entire proceedings, I think the respondent did not highlight the fact of, the separate legal entity much. So,
Yeah.
it basically, they were trying to defend, allegations made against them. So that's something which, has to be taken into consideration as well.
Exactly.
Like they're saying that we are not responsible. So.
Yeah, and the other point is that they, when the issue of Shanghai Oil came up, it was very clearly said, and the evidence is there before us, that they said, well, it will not affect the relationship between China Oil and Bangladeshi Oil. We are not running away from it. So, all in all, my thinking is that although they were the bidders, yeah, but they have not signed. Nevertheless, the authority to sign was given by them. It was signed by their employee, and they were the beneficiary of the contractual profits. So they were really behind the scenes. They were really what we used to call, the alter ego. So China National is the alter ego of the company. And because there is no positive objection to jurisdiction, and the way that the clause has been put in the written statement, I think there is an admission, and I think Samir probably agrees with that, because both of you know that my position is that you have, if you have a challenge to jurisdiction, you must make it very early on, and you must make it very clearly and very loudly, so everyone knows that you're screaming and you're saying, "No, I'm not responsible for this one. If I'm the wrong party, don't bring me in." So they have not done that. So my view is that by reason of those facts, it should be that they are a proper party, properly brought in, and they have not challenged jurisdiction. So we have jurisdiction to deal with them. Okay, so that would probably be my view. Unless you have any contrary thoughts, then we'll go along with that. And if
I'm agreeing with that view, sir.
Okay.
No, we'll go along with that.
Okay. The liability is a more difficult one. The liability is a very difficult one. And I don't know who chose this question. The person who chose the question, I don't know whether it comes from. Were you responsible for that, Shami? I don't know. But it really sets us thinking. The tribunal. It's almost like a real case that you get. So what we are starting with is that there's no contractual provision. This contract was done before people got to think about decommissioning as an express contractual term. So you have to, the claimant has done, they've relied upon an implied contract or implied term. And also, the other side are basically saying, the respondent is saying, hey, look, there's nothing in the contract. Why are you talking about this? And it doesn't fall within the contractual obligations. So why should we do it? Then there are the analogous issues of the license, the environmental laws, and which have to be followed, and whether the good oil field practice includes something which is post extraction. So you finished with a field and then it doesn't exist anymore. It's no longer an active field. Whether the obligations, whether the obligation of good oil field practices will apply to such a field. So those I see are the issues. So, Samir, do you think there are anything else on liability that we need to decide?
No, sir. Thank you. Those are exactly the issues that you've rightly pointed out. The liability is tough to impose on someone who's not even here and is not a party to the contract. And how we're going to be dragging them into this liability issue is something that needs to be considered more at length.
Yeah, but yes, the thought that I had was this, that if you got over the proper party jurisdiction issue, then the liability will just attach to the company which is there in front of us, right? So how can we go to someone else? Because we can't give an award against Shanghai Oil, and the only other thing would be that we deny relief to the Bangladeshi claimant. So I think we'll have to decide this as a separate independent issue as to whether liability exists in a situation where there's a contractual vacuum, but there are other factors you take into account, the environment and ecology and things like that. And this is something that is very important, because can you ignore the environment? Can you ignore ecology when you're dealing with something like this? And we know about the hazards of pollution and stuff like that from this sort of operation. And we know that this is it's a red category operation, basically. It's a red category business for environmental purposes. So, and today, the mindset of every lawyer, every contracting party is on the environment. So we're talking about environment and ecology. So that is taking precedence. And when we look at any contract, we are supposed to look at the environmental and ecological factors as well. So you can't ignore them, and you can't say that it excludes all of that. The evidence was also fairly clear that in that context, getting the renewal of the license, they had to put in something. And I think the evidence establishes that there is some evidence that a plan was given or submitted to get the environmental license under the Environment Protection Act, I think of 1995, that there should be something about decommissioning, and the operating company of China Oil in Bangladesh obviously put that forward. So whether it was put forward by them or whether it was put forward by the Chinese company makes little difference, but obviously it brings in the ecological factors and the environmental factors. So that's how I'm looking at the issue of liability, whether they are liable for decommissioning or not. So what are your thoughts, Margub?
Sir, taking everything into consideration, sir, my thought is basically, is that even though, I'm agreed that we have jurisdiction over, because of the way, the entire thing has been done, and the structuring and the arguments and the admission. But I think I'm of the opinion that, you cannot impose a liability on this company which is not in the contract, number one. Number two, and particularly the fact that, this basically costs 1/3 of the entire amount. So it's 100 million out of a $350 million contract. I do understand, I am mindful of the environmental impact, But there is that provision of law which was referred, in which it says that the coastal state is responsible for the decommissioning. I think that is something which I would have taken into consideration, plus the fact that nowhere in the contract it has been expressly included. That is clear that it has not been included. The rationality of it being implied, I don't think we had enough evidence, for example, that it has been implied in any manner. I mean, it's a substantial act. It's a substantial, performance obligation of the party. So that is something. Plus the fact that eventually, this has been included as a separate provision in the contract also says a lot about, it being a specific obligation of the party. So I am of the opinion that, as it was not part of the contract, so the respondent cannot be held liable for decommissioning.
I think sorry, if you allow me, just to add on Margot's point. I think in the absence of an express contractual provision, one must look at, and I don't have the statutes in front of me on which the councils are relying upon, one must look at the wording of the statute. If the liability extends to the parent company, and I know that environmental legislations are quite broad in terms of who is going to be responsible. So if the wording of the statute is such that it extends to the parent company or the shareholders as well, then only a liability issue can maybe imposed upon the shareholder company, because the actual work and everything was being conducted, although it was being ordered around by the principal shareholder, but it was being done by a separate legal entity in Bangladesh. So the performance was being done by someone else. And unless the statute allows you to go back for the liability of that particular company back to its shareholders, I think we'll have a difficult task imposing certain liability. Obviously, we can assume jurisdiction, but does not necessarily mean that we have to impose them with certain liability for this particular issue.
Plus,
that was just my thoughts.
Yes, just to add on to that as well. Sir, that some of the questions that I asked was particularly in relation to that environmental license issue, because that was the key issue. That if there was a commitment of decommissioning in the project itself, then what impact that would have. Now, what I think we need to consider is that whether the Environmental Act basically compels the contractor to follow it through, or whether even if there is a mandatory provision of decommissioning, which I'm assuming there is, whether the coastal state having carried out that would satisfy that provision. So that is something which I think, and as far as I've seen, without really delving into the laws and everything, I would assume that it will be the responsibility of the coastal state, having not, and they're not including it in the agreement, are basically responsible for carrying that out.
Yeah, the issue today for us is not whether the coastal shelf has responsibility, state has responsibility, or whether the owner has responsibility. It's a question of whether the contract, because it's a contractual dispute that's before us. Okay, so the essence of the contract is, essence of the dispute is based on contract. So it's a contractual dispute saying, well, we entered into a contract, production sharing agreement, you have an operating agreement. Although it is not, decommissioning is not set out in either of these agreements, you are still responsible contractually. So we're not looking at the law of the seas or anything like that. That I think is an escape route taken by the respondents to say, well, it's not my liability, someone else is responsible, okay? Or you are responsible under the international law, under international law, because of you being the owner of the property. Okay, so that's the answer. So those could be valid defenses, of course, to a liability issue. But that I said right at the beginning, this is it's a difficult issue, and obviously what we need to see is from a legal principle whether we can attach liability on the basis of an implied term of the contract, and the implication arising out of the legal provisions relating to the environment, or can we rely upon the international practices under Lex Petroleum, the law of petroleum, which has come up, so again, this is an international thing which has come up. So that is how we can look at it. So it's essentially a contractual dispute, and we have to say whether it comes within the contract or not. And what we are bringing in from outside, or what we are using from outside to exclude liability or to include liability, is something that my view is it's a difficult issue. And hearing the evidence, I've been sort of wavering between liability and no liability, liability, no liability. And I think that this is my view, that there is liability here under the contract by reason of an implied term, and by reason of the fact that that environment is very important. There was a license. This is a red category. So, it's a job. You take on the responsibility to do something. So this is oil field. You drill, explore, you extract, and then you close, and then you go away. One or both of you may remember that I was involved in the Sylhet, the Chatok oil field dispute, where there was a blowout. And I got involved because I was representing the Texan company, which had come actually to put out the oil field, the explosion that had happened. So, I've been involved in this sort of business for some time. But I think you not only look at the extent of the contract, that you start the contract with the, with the drilling, your research and the exploration, and et cetera, the extraction, and then, but the contract really, you go to the end of the contract is not just when the well has dried up. My view is that it doesn't end there. It ends, you finish the job by saying, okay, fine, we have closed the hole, and we have done whatever needs to be done, capped the hole, and we have basically taken all the structures which should be taken away, and then we've left it back in the way it should be, after an exploration of this sort. So even though it's not in the express terms of the contract, it is my thinking is that there should be liability on the basis of an implication, because if you were to ask the fly on the wall, or the man on the Clapham omnibus, the reasonable man, what would the reasonable man say? When does this activity end? Does the activity end when the gas runs out or the oil runs out in the oil field, or does the activity end when you have actually closed your functions and taken away whatever you put there, and left it back as it were before you started the operation? So that's the view I personally take, because you might think it's a pro-environmental approach, but that is the way that tribunals are thinking nowadays. And so you go beyond the strict legal terms, and you look at the environmental approach and so on to imply terms. So, so that's the view I take. Now, if you disagree, both of you disagree, we'll have a dissenting award. But if you want to go along with me, then, that's the reasoning, that's the rationale for us for me, for saying that there should be liability here. Samir.
I think obviously, sir, you know much better about the current mindset of the arbitration landscape, and especially surrounding environmental issues. So I would go with your suggestions. We are all. I have not dealt with any environmental law issues, so I wouldn't try to. I'm seeing it from a purely strictly contractual liability perspective,
yes,
and a statute commercial arbitration perspective. But if you look at a holistic environmental approach, you would know better as to what the recent decisions are in relation to this and the recent mindset is. And I think these students who are before us should also understand the mindset when they're dealing with such issues. So I do not want to confuse them by saying something different.
That's very helpful, Samir, because you remember that, of course, I think it came out in the arguments today that we have signed certain international obligations. Okay, Bangladesh has signed certain international obligations in respect of saving the environment, et cetera, et cetera. So, and the mindset of the tribunals and courts today is that you protect the environment. So wherever you can, it is reasonable to take a step or to look at a contract which protects the environment than one that harms the environment. Okay, so I think that is the way that it's been looked at nowadays. And also where a state has taken on an international obligation by a treaty, then the obligation of the tribunals and courts within that jurisdiction is to try and work in a way which is consistent with the international obligations of the Republic. Okay, so, as a lawyer, you know that, and Margub knows that. So that's the way I've been thinking. And so if you're happy to go along with that, let's see what Margub has to say. Are you still dissenting, Margub, or are you thinking that you'll go along with the environmental lobby on this occasion?
Sir, I am agreed with the fact that it's an environmental issue. But my question basically is, sir, that whether the environmental requirement, compels us to basically request the tribunal to impose the liability upon the respondent. I mean, there's definitely an environmental requirement, and as you have said, the state has signed international treaties, and there's obligations coming out of those treaties upon the state to protect. But that is my question. But I understand, sir, where the rationality of protecting the environment, and also to an extent that they have been submitting the documents for the environmental clearance, and making if those documents somehow makes a commitment of decommissioning when they leave, that is something where we can go along and maybe impose liability. I mean, I have no issues that the liability imposed on Shanghai will directly be imposed on the respondent. I have no issues with that because of the we have assumed jurisdiction. But it's just that as long as the commitment was there that they will do so. So in that case, I will be agree to you with your views.
And I must say that I'm not deciding this on the basis of what my heart says. Okay, I'm deciding this on the basis of what the law says, because my heart would always say, okay, we'll go for Bangladesh, right? Well, for all our hearts would say exactly that. But as an international arbitrator dealing with an international dispute, you're not deciding an issue on the basis of what your heart says, but you're deciding the issue on the basis of what the law says. And that's why I'm reading the law, and it may be we're being proactive, pro-environmentalist, but there is good reason to say that the liability should be implied. Okay. So if you're happy with that, then we establish a liability, or if Margub says that, no, I'm going to give a dissenting, but we're happy for you to give a dissenting, but Samir seems to go along with me on this.
I don't intend to dissent.
All right, thank you very much. Then the question of quantum is quite easy, isn't it? Because quantum was an easy one. They said, well, if liability is established, 100 million is the cost estimated by the respondents themselves. Other cost, quantum has been given over 200 million. So in that sense, it's less than half what the other people have paid in other contracts. And they're also saying, well, because they had 70% of the share of the profits, they can only, and we had 30% of the share of the profits. So we are actually sharing. So the Bangladeshi company is also sharing it. So it's saying, okay, we'll take responsibility for 30%. So I would have thought that the answer is yes, they're liable to the extent of $70 million.
Okay. I'm agreed with that, sir.
Yeah.
Okay. Right. There was a message which was sent to me. I think we're now at the end of our deliberation. So we have established that the proper party to the arbitration is China National Oil Company, which is the parent of Shanghai Oil, and so we have jurisdiction over it. We've decided there should be liability here as an implied term of the contract, and then as far as quantum is concerned, this should be $70 million to be paid by the respondent company to the Bangladeshi company. Right? So is that the decision?
Yes.
Okay. Thank you. Mr. Rumi, are you still there? And someone from BIAC?
I'm very much here, but you are also supposed to, we'll have there was another award which we are supposed to give. and that was the best. I think the best.
Yeah, of course. Sorry, which award? So as far as the claim is concerned, we have decided by unanimous decision that
the winner.
it is
That has to come from
the claimant wins. Okay. So that is that, and then what else do we have?
Lost you.
What else do we have to decide? Rumi?
Yeah, come now. I think we lost you for some time.
Okay, sorry. Can you hear me now?
Sir, we have to decide best participant and best teamwork.
Oh, best participant, best teamwork. All right. Well, I will let Samir decide on the best participant, and let Margot decide on the best teamwork. And
Mr. Chairman, which is the team?
Thank you, sir. Sorry.
No, Margot was going to say something. Was you saying something? Margot, you've muted yourself.
Sorry, sir, I didn't hear. The Samir is to choose the best participant, and I couldn't hear what I'm interested in.
Oh, you're to choose the best team. Okay.
The best team.
Right?
Okay.
Is that what we have been told by BIAC?
No, BIAC, you have to declare a winner. You have to declare a winning team. Which is the winning team?
Right. Okay. So we won so we've decided who the arbitrator is. We've got to now decide who is the winning team. Okay. And fine. So this, I think we should decide together, right? Margot?
Yes, sir. The winning team, I think, follows the result as well. I think I would say the claimant.
Absolutely. Samir, do you go along with that? Winning is like an order.
Sorry, which one?
The winning team would be who got the result. So it's like costs. You win, you get your costs. You win, you become the winning team. So the winning team would be the Bangladeshi team. Okay, Ali Ashraf team, right?
Yes. Claimant. Yes.
So I would like to, given a chance, I would like to say something about the respondent team as well.
No.
Whenever I think there's a time for that.
Absolutely.
No, first you have to declare the winning team is Dhaka University, is it?
Yeah,
the winning team is Dhaka University.
Well done, Dhaka University.
The best participant, sir. Should I continue with the best participant?
Yes, please.
Yes, please.
Well, first of all, I'd like to thank all of you for your patience and commend all councils for the able jobs that you did. And it's very difficult to choose one. And I was just thinking that I was hoping that sir would not ask me to make the choice, because what makes a good participant is the several things. It's the composure, the eye contact, the ability to respond to questions quickly and simultaneously. And what I have learned from my senior, Mr. Adonson QC, is that you have to sound interesting. And even when I'm doing the submissions at this point in time, unless you can get the attention of the arbitrator or the judge who is judging you, it's a gone case. So with all this in mind, and without, obviously all of you, with the disclaimer that all of you have done excellent, I think the best participant would be Mr. Jalaluddin. Jalaluddin would have my vote for the best participant. Not for anything else, but the way that he has responded to the questions with the confidence, and he just sounded more interesting than the other witnesses to me. And when he was speaking, I was engaged. And it takes a lot to get me engaged, unfortunately. But yes, when he was talking, I was feeling like, yes, I was actually in an actual hearing. So, sir, Jalaluddin gets the vote for me from my side. Because I also gave him a very good mark on the score sheet as well.
That's excellent. So you've gone for the witness, right?
We've got for the best participant, the overall participant with the body language, the eye contact, the composure, And not necessarily the witness. Witness was just the category in which he had performed.
Absolutely. I was absolutely right. You know, I go along with that. Margot, your thoughts?
Yeah, I think he has been very good as well. He has been very confident and he has been very good. But I have, I will, I think everyone did really well. And you understand the deliberations that we had gone through and everything. The questions were intense because the participants were that good. They both, the respondents' case and the claimants' case, they placed it so well. And I think it was very good. The opening statements, I would just like to highlight by both the parties were excellent. I think it was very good and it was tremendous. I mean, I think the respondent's opening statement was very good, and I liked how she controlled everything. She composed herself and did that, and the claimant was equally good. But some of the things that I would like to say is that, guys, slow down a little bit. I face it as well. You just need to slow down a little bit. You just need the tribunal to be at pace with you. You know all the facts. The tribunal may not know all the facts. So you just have to make them a little bit comfortable at the same time, not monotonous, but just slow down a little bit. I think you guys did brilliant, and I had a couple of points, but I think Sarah will say it. So I understand there was a time crunch, but I think in general, I think it was great. I really enjoyed it, and thank you, BIAC, for arranging such a thing.
Yes, absolutely, absolutely.
Yeah, Rumi, I just wanted to add that I would certainly go along with that, but I remind everyone of the story that we have. I tell this story because there are some mock arbitrations that I do actually chair, and when I tell the story in England, everyone really enjoys it, and I think I should share this with you, because this is the story about the tamarind tree in every court building or near every court building. You know that tamarind tree, the tetul gach? So underneath the tamarind tree, near to every court building, you will find a lot of people, under the shade of the tamarind tree. And some would be, selling tea or biscuits or refreshments or cigarettes or whatever. But there would be also a category of people who are actually witnesses for hire. Okay. So, I speak in Bangla, tetul gacher tolar shakhi ar ki. So we're talking about people like that. So there are people, witnesses for hire, and these people come along and give evidence. What impressed me most in this case, and Samir's choice of a witness as the best participant just highlights the point that, I'm really amazed at the way that the witnesses have performed. Everyone has performed fantastically, but these witnesses, obviously they have only been working from a script, not from reality of what has happened. But the way that they have given their evidence, they could have fooled anyone. Okay, so they would have done the best. And so, if you do not make a good, do not end up in the profession as a good lawyer or as a good arbitrator, you always will have the opportunity of finding a tamarind tree near a court building and join the people who are the witnesses for hire. So that is a joke. I know that all of you will be very, very successful, not only as lawyers, but also as arbitrators and arbitration practitioners. I wish you all the best. One of the things I wanted to suggest to you, Rumi, is that perhaps you might want to set up what's called a law clinic, and you can help, young people who are at the universities basically, or just passed out of the university, and help them to help people who really need help. And like small disputes, they can help commercial disputes or whatever, matrimonial, family disputes. But you have
একটা ছোট্ট পয়েন্ট ছিল। Sir, if you allow me, আমার একটা ছোট্ট পয়েন্ট ছিল with respect to Ishtiaq bin Farouk, the counsel for the respondent, the closing dilo.
Yes.
Your submissions were really good as well. But একটা জিনিস যেটা আমরা সব সময় শুনে আসি এবং শিখে আসি সিনিয়রদের কাছ থেকে, যে হচ্ছে যে know your materials, because তোমার একটা জিনিস তুমি করে বললাম, I hope you don't mind, তোমার একটা জিনিস হচ্ছে যে তুমি বলতেছিলে একটা জিনিস, কিন্তু সাবমিশনে কিন্তু মেটেরিয়ালসে কিন্তু আরেকটা জিনিস ছিল। এবং আমি যখন UCL এ পড়ালেখা করতাম তখন I participated in this exactly moot arbitration, and sir ওখানে the arbitrator was Lord Justice Sedley, who later went on to become the Court of Appeal judge in the UK. And I was up against this Indian fellow, at the finals, in the finals. And I remember Lord Justice sadly telling me, Mr. Sattar, it seems like you're praying for rain and getting wet in the process. জিনিসটা আমার কাছে এরকমই মনে হচ্ছিল এবং আমাকে ওই 2009 এ নিয়ে গেল আমার মাস্টার্স ইয়ারতে। So always know your materials, which is very, very important. Whatever submissions you make, if something is there on affidavit and or otherwise in writing, which is completely contradictory, then your case will fail and your credibility will be lost. So that is very, very important.
Thank you, sir. Thank you so much.
Yeah. So all of you done
One more
very,
thing,
very
sir.
well.
I want to say the University of Dhaka, your pleadings were excellent. You had, and I know sir would like it for a fact, but you had so many references and it was excellent. I think the pleadings were very good.
Yeah.
Thank you so much, sir.
One of the things that I noticed, I was just going to with this, I'm going to conclude my submissions and my discussion. Basically, you know, what we do is as advocates, and we also as arbitrators, you know, we prefer a counsel to start off by giving a very short summary of the facts. Sort of just giving a very short summary. This is what this case is about, you know, in 5 or 6 sentences. And then go to what the issues are. Okay, so these are the issues, okay, 1, 2, 3. And then make your submissions on each of those issues. And then it becomes, you know, it follows a pattern. And we then catch on, okay? So, you know, in the old days, judges did not, or arbitrators did not read the papers in advance like we do now. Now the rule is that we read the papers in advance, so we are aware of the case. And you would have seen that what Samir has done is that he had actually looked at the pleading. You know, he went to the extent of looking at the pleading. I have done some of the reading, so I knew what the issues are going to be. But nevertheless, it would always be helpful because sometimes, you know, arbitrators, you will find they're flown in from different parts of the world to the arbitration hearing. You know, they probably did not have a good night rest. They're all jet lagged, and the next morning they're starting an arbitration hearing pretty early in the morning. So in that sort of scenario, you know, it is always helpful for the advocate to basically start off by saying, well, this case is about this. These are the issues which you have to decide. These are my submissions, and then go into the submissions in depth. Okay, so do it in that sequence. That becomes very, very useful. One of the things that it's just don't take it as a negative comment. You know, I know that this is something that has happened, that does happen in the films and things like that. So while you're actually cross-examining a witness, you are making submissions as well to the counsel. When you're cross-examining a witness, just cross-examine, you know, then you don't make submissions to the tribunal. Submissions come at the end. Okay, so there's nothing to point out during your cross-examination or taking your evidence in chief. Whenever you're taking your evidence, you just ask questions to the witness, and that's it. And you don't make any comment. You don't make any address. You don't make any submissions to the tribunal. You just do your job by asking the questions, establishing the points that you want to establish. So that is those are the 2 things I want to tell you as a matter of how to improve your style and how to become better advocates and arbitrators in the process. So, but you've done very well, all of you, and congratulations to all who participated. I was really impressed by everyone. Certainly, as I said, I was really impressed by the witnesses, as if they have really lived the whole thing themselves and they were relating their experiences to us. So in the old days, we used to be told that when you're hearing evidence, you should look at the witness to see how they're behaving, their mannerism, things like that, the body language. But you know, from what I have seen of the witnesses who have given evidence today, I'm amazed. And every time I see this, you know, in a mock tribunal, I have the same comment, that I find the people who are giving the evidence are so convincing that you will never be able to find out from the body language that they have not really lived through this. Okay. So there we are. Thank you very much, all of you. And thank you, Rumi, for giving me this opportunity to chair this tribunal. Thank you to my colleagues. Thank you all who's been participating and who have been watching. All the best to you.
Sir, there was a message wishing you advanced happy birthday. So if tomorrow is your birthday, then a very happy birthday from all of us to you.
Thank you very much. Now that that is out of the bag, I can tell you actually what I'd done was I'd taken my grandson out shopping and I forgot about this whole thing. Okay. That was the reason why we were late by half an hour. Okay. Okay. All the best. Thank you. Thank you very much indeed. Thank you.
Thank you, sir. Congratulations to the champion team, University of Dhaka, and runner-up team, BIAC Academy. I would like to conclude the session by thanking the chairman and members of the tribunals and the team members of 4 universities along with their faculty members who worked hard to train up and prepare their students for this contest. I'm Mahbuba Rahman Runa, General Manager of BIAC, was the host and coordinator of this contest. Thank you all for being with us and enjoying the contest. See you next year. Allah Hafiz.
Thank you very much.
Thank you.
Bye.
Thank you very much. Allah Hafiz.
Allah Hafiz.